Good evening. Happy Friday. Happy Friday indeed. It is Friday, January 10th, 2025. 10 days into the new year, and I still feel like it's 2022. So glad you guys are here. Happy Friday to all of you. Welcome to the channel. Welcome to another Friday Night Frenzy where we talk about all the crazy things that happened in the law this week. But there were too many crazy things, so we've narrowed it to two topics. That was too long to fit on the thumbnail, so we stuck with just Supreme Court and Alec Baldwin. How you guys doing? How was your week? How many of you were affected by snow? I'll raise my hand. I'm going to raise my hand. Very high. Oh my gosh. So it's been a wild start to the year. I live in the Northern Virginia area. Oh, hi, everyone. I'm Rob. Nice to see you guys here. I live in Northern Virginia, and Northern Virginia got hit with a snowstorm after about 5 or 6 years of not having any snowstorms. And when I say a snowstorm, Ian would laugh at me, Ian being the Canadian elf from down yonder / up in Edmonton. We got 9.6 inches where we are, which was enough to cause a panic that lasted the entire week. So I was supposed to have trial on Monday and Tuesday. Holy crap, it's been that long. This week has been long. Wow. That hit home a little harder than I thought it would be. Yeah, so I was supposed to have trial on Monday and Tuesday. That did not happen because the courts closed. Schools closed, the courts closed, everybody closed. It's been a while since the courts have closed. So that was fun, prepping clients on Sunday night, and then all of a sudden not having trial. Always fun. We can get into that in a little bit. But yeah. See, this is obviously Witchy Jesse, obviously Canadian or some other place that gets more snow. Because there's another one laughing at Canadian. See, I'm telling you, it's enough to shut down everything. Absolutely everything. So we had courts shut down Monday, and then lo and behold, I thought I was going to get my hearing date on Tuesday. Nope. No court on Tuesday. That was fun. And then I had to reschedule everything. For those of you who don't know what happens when the court closes and why courts tend not to close or try not to close. When the court closes, they are scheduled to hear, I don't know how many hundreds of hearings that they take place that particular day between the general district court, which hears traffic matters and small civil matters and small criminal matters, juvenile court, which hears custody matters, visitation matters, offenses involving juveniles or families, and circuit court, which hears, murder cases, divorce cases, all of the above. You shut down a courthouse for a single day and you cause a lot of chaos. You let that shutdown continue for 2 days and all hell breaks loose. So Chief Judge Penny Ascarati, Chief Judge called all hands on deck on Wednesday to try and handle the rescheduling. The rescheduling was pretty wild. It resulted in several hours on the phone with all kinds of people trying to get cases rescheduled, redocketed. And all of that was before you considered the fact that when there are two tiny, small humans that were supposed to be at the end of their winter break, and they were not at the end of their winter break, and you were blessed with their presence for additional days at the end of 2 weeks when they have been ferile, and you give them snow. Well, it makes for a very fun week. Very fun indeed. So the week was pretty wild. And the week continued that way because, go figure, on Wednesday, the courts were open, but the schools were not. And then for good measure, why not? Kids are off for 2 weeks. Heck, let's close schools on Thursday too. Now, I learned something. I learned that I think there's 4,500 bus stops. Hang on. I got to look this up. How many bus stops are there in Fairfax County? Bus stops for school in Fairfax County. I want to say 4,500. Anyways, there were at least in excess of 4,000. And I learned that 60% of those, because we had the lovely snow, then the hard freeze, 60% of those were still completely uncleared on Thursday, which is why they had to close schools on Thursday. That was cool. And then today, Friday, they had school, but it was a 2-hour delay. What's the point at that point? Like, why are you doing that? I don't understand it. Why couldn't they just make the decision early in the week, kind of predict we're not going to have this happen, and then just let us do that? So why? So that resulted in a lot of very happy people. Happy people indeed. We deal with happy people in my profession all the time. So it made for a very interesting week and a very interesting end to the week and beginning to the next week. But we've got some fun stuff to talk about because we had a Supreme Court oral argument that I anticipated being interesting, but holy crap, did that become rather spicy today. And I became very fascinated. And that's before General Prelogger started talking. I haven't heard General Prelogger's part. I just got to the part where the TikTok attorneys had stopped and we hadn't gotten to the government's position yet. So we're going to have to do a whole recap of that because holy crap, that was a lot of fun. There's a whole lot of confusion about the issue. So I really want to talk about it. But what are you guys up to? How was your week? Chime in. I want to hear what you guys are doing. Where you're tuning in from. Looks like Court TV is here. Hey, Court TV, glad to see you. Court TV, question for you. Very big question. The murder case that's taking place here in Prince William County. Any chances I can get you guys to tune in on that one? And I'll give you the site here in a second. And I think you're going to want to see it because actually what I predicted is happening or was going to happen actually did happen. Actually, this is a good kind of beginning to the show because people have been curious about this one. And it's something that I've been following a bit. Go back to where was my docket? Where's my docket? Rob, where's your docket? There's your docket. You found it. I found it. Ah, yes. In the case of Naresh Bhatt. Hang on. Pull this up and share this real quick. So you guys might remember this case. We talked about this a little bit ago. But an individual was charged with concealing a body in Prince William County. Here we go. Individual was charged with concealing a body in Prince William County. So this is reporting from CNN. Sorry, but it is. Naresh Bhatt, husband of missing Virginia nurse and mother, was charged with murder. You guys remember back a while ago, we had a charge that was made for concealing a body. And back when that charge was made, the defense counsel that was court-appointed counsel said, I am not going to waive speedy trial. I demand speedy trial. And what did I say? We were going to get right up until the week before the trial, and the grand jury was going to come back with a superseding indictment, which restarts the clock. And what just happened? Very curious, though. We don't have a whole lot of new details. So this is an interesting one to just hit right off the bat. Grand jury has handed up a murder indictment against a man whose wife disappeared this July, sparking a flurry of concern in the Nepalese community of Northern Virginia and beyond for the nurse and young mother. Naresh Bhatt's now facing state charges of murder and defiling a body. Prince William County court records show. Court TV, hey, Prince William County, right down the street from me. I would gladly meet you guys there and hang out for a bit. I think this case would be really interesting. I think it's probably going to be a week, maybe on the outside 10 days. Easy court appearance. Plus, Prince William County judges, they're fine. Get that media appearance done in ASAP. Because I'm very curious as to how they're going to prove this case. So Bhatt, former Fairfax County police recruit and former U.S. Army Reserve automated logistics specialist, already faced a felony charge of concealing a dead body. We talked about that. He's been held without bond since August. Made sense because it looked like he was actually selling his vehicle, trying to prepare an easy escape. Bhatt's trial on all three charges set to start September 8th. Look, Court TV, plenty of time. In court Wednesday, he waived his right to speedy trial. Makes sense. Now that the superseding indictment is in, you need more time to get the information they're going to bring in front of you. Let me explain why that happened. Sorry, that was fast. Back up for 1 second. Shrinky screen. Okay. So, initial indictment, initial charge, concealing a body. No murder charge yet because they don't have the body yet. They're still pursuing the investigation. When they brought that initial charge, there was still a whole lot of search warrants being executed. So you're sitting there going, how are you possibly going to prove murder as to this individual when you don't have a body present? You don't have a lot of the information. You're still executing search warrants. But they had to charge him because they were concerned he was going to flee. So they charged him with concealing a body, which gives you the ability to bring him into court, detain him. And then he asked for bond. The judge denied the bond because he actually was engaging in behavior that might suggest imminence of flight, selling the vehicle, disposing of evidence, alleged evidence. We're going to stick with that. So they issue the charge. They arrest him. They bring him in on this, and in the interim, they're continuing to do the investigation. Well, when they first bring that charge as a defense counsel, you're sitting there going, I've got a pretty good shot at this because they still don't have a whole lot of their evidence. So I'm absolutely going to demand that they bring the trial within the confines of the law, which is 60 days. They have to bring that trial to trial within 60 days. That's federal. We looked this up in state. I think it's 60 days. Anyways, very accelerated time frame. So at that point in time, as defense counsel, it's within your interest not to waive speedy trial. You want speedy trial. You want to put the government on their toes because even though you are disadvantaged by the inability to gather information, the government's disadvantage plays in your favor. It's their burden of proof. They have to prove it. You don't technically have to prove anything. You just have to defend the case. So that was all valid right up until you get this new charge. The second they issued that superseding indictment, which means they continued their investigation, they get right up to the eve of trial, which is the last possible second before they can before they have to go to trial, they issue this new indictment. At this point in time, as defense counsel, now they're charging for murder. Now you actually need additional time because the stakes are higher, the circumstances are changed. So in this point, your interest is in actually waiving speedy trial. You actually want the time to do discovery yourself. That's why that was done. That's why that decision was made. It was pretty smart. It was pretty well played. And actually kind of played out almost exactly how we thought it would. So, Kaftabat, 28, mother of a young daughter, has been presumed dead. According to authorities, no one's been able to find the beloved Nepalese community member since July 27th, which was last seen at UVA Health Prince William Medical Center in Manassas, where she worked as a registered nurse in the medical surgical unit. Oh, there we go. Here's the new evidence. DNA tests now have proved blood found in the bedroom belonged to her, with evidence showing she was killed July 29th, Manassas Park Police Chief said. Interesting. DNA test result, which they got in the interim, helps the case and kind of certifies what we thought occurred. They feel they have a strong case. They would obviously say that. Blood pooling, blood spatter in the home. White pink stains, carpeting, and blood in the bathroom. Prosecutors have told the court that he had been recorded on a camera driving his car, sometimes at night, disposing of trash bags and dumpsters and trash compactors in the days after his wife was reported missing. Be there for every court hearing. So the family community has been very active in this case. The family community is actually what got this in national media coverage. So it's a case I'm following, Prince William County. It should be pretty interesting to watch. I'm actually very curious when this thing goes to trial. Quick update, very short update. And the only reason I did that, I had a schedule, is because Court TV was here and I kind of wanted to persuade them, to maybe take a looking at this particular case. But that's just selfish on my part. I could use an actual case that doesn't result in, brain confuddling frustration. This one seems relatively straightforward. So, could be very curious. All right, catching up on the chat. It's been flying because I was focusing on the screen and talking. Oh, looks like Court TV has at least done some coverage on it. So hopefully get a little bit more. Very cool. Tracking for sure. Hope to see you in Prince William. Let me know when you get in town. And if you want anyone local to kind of give you a little bit of the lay of the land, it's up to you entirely. But Prince William County happens to be, it's a very curious jurisdiction. So Fairfax County is the largest of the jurisdictions in the Northern Virginia area. And it's probably the one that has developed its most internal mechanisms, right? So the surrounding jurisdictions complain that they don't want to be Fairfaxed. They don't want to become the machine that does a really good job. Nah, that's bias on my part. They don't want to become more of the machine. They want to stick to a lot of their procedures and policies. Well, the thing is, Fairfax had to do that because of the size of the court and the number of cases they had to process. Prince William County, along with Loudoun County, have been advancing a lot of their processes. I say that with hesitantly. We are developing certain things. For example, in Prince William County now, I can at least electronically submit in documents for filing. Loudoun County, I can't. But these courthouses and the rules in the court are still very much unwritten. And navigating those can be rather complicated. So I would say that young attorneys, while Fairfax can seem daunting, at least all their rules are written down. You go into a courthouse like Loudoun County or Prince William, 50% of them are written down. 50% of them you just expected to know. So it can be kind of complicated. So getting caught up, please. That was a bit of a sidetrack. For those of you curious, I did take my medication today. So we are not going to have a repeat of last week. No. Plus, we're covering Supreme Court stuff, which I love and get very interested doing. Okay. Body cam with the husband. Yeah. So was the interview, the voluntary interview. It's going to be very curious. Corti, I'm going to check out the body cam again because I need to see what additional evidence they're going to bring forward. And there's going to be more that's going to be released. Like I said, this indictment just came down and the trial's not set to go until September. And you actually don't know if there's going to be any plea discussions between now and then, but it's definitely worth following. Just because it's going to be a lot. We're going to see some more information coming out of it. This reminds me of the Zachariah Anderson case, but Zachariah Anderson case felt a lot less solid than this one. Zachariah Anderson felt like a whole lot of conjecture. And this one feels like a whole lot of just lining up evidence and knocking it down. Yeah. Okay. Catching up on some of this. For those of you asking, Ian did text me. He's probably going to come on at some point in time. He is enjoying his Friday with his missus, with his beloved. So we're not going to judge that at all. We've got some fun stuff to cover in the interim. Tough Cookie, thank you for gifted memberships. DSN, thank you for gifted memberships. And Sandy, thank you for gifted memberships. Sandy's also drawing my attention to say happy birthday to Kestrel. Happy birthday, Kestrel. You go to W, thank you for gifted memberships. Alesha, happy Friday, Rob. Happy Friday to you. I've got gifts from the auction, from Ian's auction, are going out. They actually, 2 of them went out today. The other 2 are going out tomorrow. And I've got other packages that are out the door this weekend. I finally had, with the snow, the ability to sit down in front of some boxes and put some stuff in boxes to get it sent out. So I saw this. Mrs. Runkle got a promotion this week. She did. Absolutely. So there's more. There's tons to celebrate. Tori Amethyst, can we talk about Baldwin first before he disappeared down the rabbit hole? Unfortunately, I don't think so, because Baldwin, it would be unfair of me to not allow a very good friend of mine who's a Canadian to opine on Kari Morrisey and Baldwin finally saying, we're done with this and we're going to go ahead and file a case for a malicious prosecution. Is it going to go anywhere? I don't know. I still got to read it. We have to read it and figure out where it's going. But it seems like it's going to be rather interesting. Baldwin's just about done with all the BS that's happening. Okay. Timmy Bad. New title for the stream. Baldwin is offensive. I mean, they can both be true. They can be. Gwynnie Bly. No snow here. I have mild sunstroke. Hugs to all. Well, Gwynnie Bly, I'm sorry for the sunstroke, but at the same time, I'd be remiss in not saying that we're all a little bit jealous of the sun. So cheers. Hope you're doing well. Bonnie Nominson moved to Montana from Washington State in the 70s. No one here had ever heard of a snow day. Yeah. Yeah. One of my young associates is from Colorado. We saw a picture of him when he got sworn in. And he asked me, he goes, so what happens when it snows here? I said, oh, sweet summer child. You sweet summer child. 1, everything will close. 2, you will think it's ridiculous. 3, while you might think it's ridiculous, when you see how people drive in these conditions, you will absolutely understand why things close. They're not so much concerned about the actual snow. They're concerned about all the people who don't know how to drive in it. And for very good reason. I was driving to the office and there was about a 1-inch coating of snow that was compacted on the ground. And I'm in my truck and I'm driving at a nice pace. And lo and behold, in my rearview mirror is a Honda Civic front wheel drive tin can, which has no business being out here on the road at this point in time. Honda Civic had to have been 55 miles an hour in the right-hand lane, as if the snow were not there. Just going about it. The light turned red in front of him. He didn't care. Just kept on going. Oddly enough, it's probably the smart thing to do, even though it was a dumb thing to be on the road. People in the Northern Virginia, D.C. area do not know how to drive in snow or rain or when it starts to get dark earlier. I don't understand it. I never have. I never will. I won't pretend to. Just know that things close, and I'm glad they do because it makes everyone else safer when these idiots are not on the road. I'm sticking to it. Give them a snow day to keep them off the damn road. Teresa C., we got snow here in Tuscaloosa. 2 inches at your house. Wow, Tuscaloosa getting snow. Interesting. Light Queen, I grew up in Saskatchewan, Canada. I know all about snow. I now live in Van Isle, Canada. We haven't had any snow yet this winter. You pick your poison, folks. Amanda Page, happy Friday. All happy Friday to you. Amanda Camellia, I'm working on a hand stitch quilt that I've started New Year's Eve. I totally forgot how much I love hand sewing. I haven't really had time to sew in like 10 years. See, this is the fun stuff. You learn that when I yell at you to go make things, you actually start making things. You're like, this is a whole lot of fun. I really enjoy this. You keep doing it. See? Positive things for all. Danny, the insurance girl over the Texas Panhandle snow. Hot chocolate for you. I'll enjoy the hot chocolate, Danny. Kathy Brewer, luckily I'm retired. I can wait for the melting. There will come a day, Kathy, that I will likewise retire. I don't see that happening anytime soon, though. I love my job too much. Crazy Cat Queen had dental surgery today, and I hurt. Narcotics are not helping. Please send laughter. Wait, you had dental surgery. Laughter might not be the best remedy, even though they say laughter is the best medicine. When you're laughing and moving your jaw after surgery and pain, everyone refrain from laughing, especially Crazy Cat Queen is probably laughing right now. Volkus, hope you have a fun week this week. Just reviewing dash cam of a near miss today and still cursing. It's been a weird week. Nurse Coy, thanks for becoming a member. Dill Redmond just wanted to say thank you for your content. It got me through my MS program. Officially have my MS in cancer biology. Congratulations. Way to go. Masters in cancer biology. Congratulations. I don't know how I got you through that. It's all like 99% you, 1% caffeine. If anything, it's like I just kept you company, which I'm happy to do. Congratulations. May you continue to advance cancer research because it needs advancing. Baby Steps 22 had missed last week. We'll catch up this weekend. Happy New Year, Rob and family. I hope you for a wonderful year for all. Prayers for those north of me in LA. Prayers indeed. Absolutely horrible circumstances going on. Many, many, many lost homes. Many people that are not going to be able to rebuild their homes. There will be a lot of questions asked. That comes for a later date. Right now, it's just everyone getting themselves safe, praying for the safety of those that are affected, and hoping for the best at the end of the situation. And if we could actually start forestry management a little bit better, it'd be great. For those of you not aware, I actually was a forestry major in college. Why? It's a different story for a different day. I think I've talked about it in a members only stream. How did I go into family law and domestic relations litigation? How did I end up arguing in court with a forestry major? I took a circuitous route to where I am today. Let's just put it that way. Maybe that's the ADHD in me. Maybe it's not. We'll never know. Lynn, Rob, here the stores sell out of milk and bread the day before snow hits, even if only 1 to 2 inches predicted. LOL. I'm here too, Lynn. Absolutely here too. Queenie Bly, I prefer with there. I can rug up heater. I can only legally re-robe so much in the winter and sunstroke because I'm a doofus. Sunscreen is vital. Y'all put sunscreen on all the time. I say that and I'm going to get yelled at by Mischief because I'm the worst offender in not doing it. Please put sunscreen on. Christy Austin, my kids are going nuts like a squirrel trapped indoors. I feel your pain. I got to go to work, like actually go to my office. Mischief was stuck at home with the mischief makers. Chief mischief maker was not there. Well, I don't know if Leo has overtaken me as chief mischief maker or not. I think he might have. He loved the snow. First time seeing anything of a substantial snowfall. It was rather fascinating. That dog is a freaking goof. He does not know how to run in snow. Not at all. Just looks like a complete moron. So, actually, I want to see if I have any of those. I don't know if I took any videos of him running in the snow. Because he just, oh my God, he's so awkward. And he doesn't know what he's doing. Oh, I've got some road condition. See, this wasn't bad. Let me see if I can do. Where is this dog? Where I see the dog. But he slept well all week long playing in the snow. Oh, then he did this weird thing that I have to ask the chat. What the hell? I was whispering KLB. My bad. I have to ask the chat if this is a real thing with dogs, because I don't know that I've ever seen it before. He peed in the snow. And then he was upset that the pee, I guess, was smellable and tried to bury the pee. I don't understand it. It was confusing to watch. Let me see if I can't get to these. It was rather odd. Let's see if we can get the doofus. I mean that big doofus. Ta-dum, ta-dum, ta-dum. I don't know what to do. Look at me jump in the snow. Jump in the snow. I don't know what to do. I'm in the parkour off daddy. It's snow. It's all the snow. Yeah, like I said, doesn't know what to do with it. He's very confused. Sorry, it's the bounding for me. This dog. Oh, God bless. Oh, it's the I'm on the jump in the air and not know where I'm going or what I'm doing. And this is the behavior that I need help from the chat on. Anyone who knows animal behavior, can you please explain why dogs do this? So There is Leo's pee. He's like, I'm upset that you can see this pee. I don't like it. So I'm going to take my nose. I'm going to brush the snow into it to try and cover it. Why do dogs? Nope. Got to cover it. Nope. Uncovered that part. Got to cover it again. No. Any explanation? None. Because I couldn't figure it out. And there, this was the road conditions on the way. I'm not holding the phone. Those of you about to yell at me, I'm not holding the phone. Not that bad. It was fine. It was a little sketchy. But yeah, driving to work. So that's an update for the week. For those of you who have answered to that question on the dogs covering their pee, I'm remarkably curious to that behavior. It is so weird. I get so confused by it. He just kept on doing it. And it just, but every chance he had to get out in the snow, he was out in the snow. Didn't matter. He's just like a kid. They go out in the snow, and if you let them play in the snow, they'll be blue in the face, fingers about to fall off from frostbite. And you say, are you cold? Do you want to come inside? No. Leo, you're shivering. I can see you shivering. Do you want to come inside? Jump in snow. Brilliant. Brilliant. Absolutely brilliant. Josh H. My two Great Danes play like that in the snow. The awkwardly long legs. Did you see the video, Ian?
No. I just got here.
We'll let Ian see the video of Leo playing in the snow.
Oh, that's adorable already.
It's adorable because he doesn't know what to do with himself. He's like, there is
First
snow.
snowfall.
I don't know what to do with it. It's his first like substantial snow. So he's like, oh, don't parkour. You don't see this. That is him jumping up to my chest and jumping off of me.
Yeah, that's not a great habit. Zora does that, but she's tiny in comparison.
Yeah.
And so he likes the snow so far.
He does. He doesn't know what to do with it. And this is my favorite part. Ready? He's about to do the really goofy trot. Look at it go.
He's still figuring out those legs.
Look at those legs go. Look at it. Bounding. Just a giant goofball. Oh. Tell you, it was fun to watch, though. So Josh H was saying that two Great Danes played in the snow like that. I imagine there's some funny videos of Great Danes jumping around in snow like they have, especially with their legs, just going, I don't know what to do with these big things. What do I do? How do I run? Yeah, I can't even imagine.
And someone says they're not a troll, they're a fan. And I'm like, I don't know what I thought you were a fan. I don't know what's
No, he's a person.
We don't have beef. We got no issues.
He's a person, he is not a fan.
What is it? I also have to do a little bit of a I've got a bottle of something nicer, but this is what I'm starting with. So this is
Are we allowed to celebrate something?
Yes, I think we can celebrate now. So I am late, and because I was at a lawyer's office putting down the down payment and signing all of the paperwork for the land purchase. So, assuming nothing goes wrong, I will very soon own some dirt.
Yay! Ian owns dirt. Ian owns dirt. Yay!
So, yeah, that's sort of an exciting development, is the ownership of dirt. But also,
you guys realize I've wanted to talk about that for a while.
I know. It's like, dang. When can we sort of officially declare it? So now the other thing is And we don't need to, I think I'm probably in the bag on it. Well, I hope so. But what is it? I am in the process of trying to get a thing to put on the dirt, which I'm trying to win a bunkie.
The monkey. Yeah.
Have you been following the bunkie story on that one?
I've been following the bunkie story, and honestly, Mischief and I almost started like just going, can we compete with you? Because this is a really fucking cute house. I'm sorry for the profanity, but yeah, it's a really cute house. I
Do
really
not
want
compete with me.
I'm not going to compete with you. You have like 400,000 votes, but
I have over 500,000 now.
It's so cute. They're so awesome. I want one so bad. Oh, and by the way, the day after we talked about it on my live stream, what started showing up on my Instagram feed and everything else?
Oh yeah, that's
bunkie.
That's advertising now. It's just yeah, but so there might be bunkie content because once I get it, I have to it arrives as a kit if I get it, which I hope 500,000 entries is enough to. I'm hoping that I've squashed the competition, but just because I think it'd be super cool. But at the end of the day, I still would have to do insulation. Got to do wiring. Plumbing is going to be non-existent for a bit. It'll probably be dig a hole.
Yeah.
And but yeah, it's going to be cool. So yeah,
I'm excited. I can't wait for that. You know, now that you're here, and because the topic is going to be a lot shorter, do you want to talk about the Baldwin malicious prosecution case?
Sure. I can sum that up in about 20 words. I don't see this case winning.
No, but it's a great move.
Baldwin is super pissed. It's a PR move. And it is also to go scorched earth on everyone who's made him mad.
Yeah, but it was hilarious.
I
don't mean to say hilarious. It's
kind of a dick response to killing a woman.
It is, and it's also it's not. I don't know if it's a response to that. I think a lot of it's a response to Kari Morrisey, or at least it's supposed to be perceived as a response to Kari Morrisey.
Yeah, the thing is that in order to
win that like a response to Kari Morrisey,
he has to establish that there was no probable cause to charge him.
I know,
and it's like, I'm sorry, probable cause to charge you is made out by the following things: 1, a woman was shot; 2, the woman died; 3, the gun was in your freaking hand.
And here's the part where I'm not saying this is hilarious. Here's the part where I think Baldwin is. Let's cover the bright line stories before we get into that. Somewhat related and somewhat hilarious topic. I own a 3D printer, and I have printed various things. And there was something that was going around on social media that I felt like I really needed to print. And then it got me searching for other things. I guarantee you there's
nothing like Luigi.
No.
Okay.
There's a linear thing that it's going to make sense at some point in time. And then it's really not going to make sense. One of the things that was out there that I thought was really adorable was something that we always lose, which is this little, now, focus. There. It's a little 10 millimeter socket, which
with feet,
with feet. See, so when you wonder where your 10 mil socket went, it now makes sense. It wandered away. So there's this one, and there's one that's a 1/2 inch. So these are the two sockets, the two sizes of sockets and wrenches that always freaking disappear, always, all the time. So I found it. It was adorable. I printed it, and that got me thinking. As I printed that, I was looking for different models that were like that. So of course, I printed that in a multicolor, which is kind of cool. Right, so another little socket that printed. And then I found someone that tried to do this with a bullet. I printed it. And oh no, the arm snapped. It's okay. I'm not going to keep it for any reason. But the shape of a bullet starts to look.
Rob,
mate, it gets better.
That thing, you're gonna need a flared base for it.
It gets better. So I was like, what's this going to look like? So I printed it. And I don't know what I was expecting.
But a dildo with
think
legs probably wasn't.
I don't think it was this.
Now,
Now,
the chat needs to know.
If you can't tell, these were all printed on the same plate because they're all the same color tone, right? So
does it vibrate?
Just bad adhesion. So this is the.
He's not answering the question, chat. He's avoiding that question.
What was the question? What was the question?
Whether it vibrates.
No, it does not vibrate. This is the bullet, so you can see the casing, you can see the top. Now the problem is the filament choice was very unfortunate for this. Very unfortunate filament choice, because it makes it even more suggestive.
It really does.
So they not only have the full metal jacket, they had hollow point.
Mm-hmm.
It's not
better. You're not improving it.
It gets so much worse.
Oh, how can it get worse?
Oh, trust me, my friend. Trust me, my friend.
So I'm not.
The hollow point did not turn out better. It is still just as suggestive. It is still remarkably. Yeah. So as I was searching for those files, and I'll give people a hint, and if you can guess the hint of what other file came up, you get, I don't know, a big congratulations.
I don't know. I'm terrified to try to guess.
Did you hear the yodeling?
I heard the yodeling. Did you get a pickle?
So they had a file. I am not mature enough to be on the internet.
It's got a curve to it. This one's got a little curvature.
That,
and it's kind of got a ribbed pattern for for some additional texture
purpose. I don't understand.
This
is gonna be burned. Oh.
Wow, that's a whole decision choice right there.
But you can see logically, so there was this little guy, and I was like, that's cool. I wonder what another little model came up. It was like, oh, a bullet. Oh, that's neat. I was gonna try to filament, and then it got to that, and it's like, oh, it's a pickle. I was like, huh, it looks weird. I wonder if it's gonna look that weird when printed. And I was so wrong. It looked so much worse. It looked somewhat normal on this is cool. It's gonna print. And then it printed, and I was like, this is not cool. This looks very inappropriate.
Yeah. Rob, that is a whole thing right there.
So, on the topic of bullets and dicks, who's a dick?
Oh, so you're talking about Baldwin then?
There you go. God.
I mean, I'm going to go through the Baldwin lawsuit, but everyone's like, oh, he's going to get like all of her stuff. And I'm like, I don't think he's going to make it to pass the motion to dismiss. Right.
No, he's really not. Oh, no. So where's it? I want to know how Mischief reacted. Well, I went up to show her. No, I went up to show her. This, not. No, I wanted to show her this.
So, chat, I know you just heard Rob say that he went up to show Mischief his pickle. But I assure you, that's not.
Oh my God. Oh, this is a phenomenal idea. I have to send this to Recovery Addict. Oh my God. I've never seen a better idea in my life. That's phenomenal. Yeah, that's great. That's going to happen. So how she reacted was basically, what the fuck is that? And then I
That's
was
not
like,
a good
look,
reaction to
I
seeing
was
your
like,
pickle.
look, it can sit on top of your monitor. She goes, or it can't. Just get it out of here. Yeah. So
Yeah, that's not a good reaction to seeing a pickle.
no. It was my God. Oh. All right. Well, let's make sure we get the chats that are about this out of the way before we start talking about Baldwin or anything serious, because I imagine that would confuse some people. Gen V, did you make a yodeling bullet? No yodeling bullet. Just the pickle, buddy. Pickle. Yep. You win. Oh my God. Crazy Cat Queen. They actually have a vibrator called the bullet. There are things I don't need to know. I just don't need to. Crazy Cat Queen, what you doing with the littles? Find those little bullets? Oh, they will be disposed of well before they have an opportunity to find these things.
He means the bullets will be disposed of, not that the littles will.
No, the
just
littles
because
are fine.
that was
yeah, the minis, not the bullets, not the minis. Yeah. No, Joy W. So these are the new merchant law number store. No, no way, never ever. Oh, but Red Pen is saying, please make those available at Ian's next auction. I would have to. Here's the problem.
If they were going to be made, they would have to be made of like some sort of safe silicone, as opposed to whatever.
My God. And the problem is that I know that during this 3D printing convention they had like several months ago, there was a company that actually came out with a filament that was food grade safe off the printer. And it was this massive development. They're like, you can print things that are food grade safe. And I'm going, well, people are going to use that for an inappropriate purpose.
I mean,
oh, God.
Fair.
Oh, no. Oh. This is the maturity you get when you talk to two lawyers at the end of a week.
Oh yes, by Friday we have run out of all of the like sanity.
Yeah, we're done.
All of the decorum,
which is kind of what I'm thinking about Baldwin. So I'm going to swoop to this real quick because this is Baldwin. Baldwin made a choice. I just don't think it was a smart one.
I mean,
let's swoop. So. Alec Baldwin. Let's just go to the AP. We'll just report on this real quick. Alec Baldwin sues for malicious prosecution after judge dismissed the case of fatal Rust set shooting. Actor Alec Baldwin has filed a civil lawsuit for malicious prosecution and civil rights violations in the fatal shooting of cinematographer on the set of Western movie Rust. The lawsuit was filed Thursday at State District Court in Santa Fe, where a judge in July dismissed the charge of involuntary manslaughter. We covered that extensively. Baldwin also alleges defamation in the suit, saying the prosecutors and investigators intentionally mishandled evidence as they pursued the case.
Yeah, so they're going to go with defamation for presentation of evidence in a courtroom. This is yourself.
This was a decision, and I think it was the absolute freaking wrong one. Defendants named in the lawsuit include Morrisey, the Santa Fe District Attorney, along with 3 investigators from the Santa Fe County Sheriff's Office and the County Board of Commissioners.
You know who wasn't named?
Who? Anna?
No. The prosecutor that got off the file.
Oh, yeah. The one who came in at the last minute and then was like, see you later, I'm out.
I think she's cooperating. We'll talk about it when we go through the lawsuit in detail, because I'll do that at some point.
Yep.
But I'm pretty sure Erlinda Johnson. I think she's probably
that's right.
I think she's playing ball with the with Baldwin's team. So
to what end?
I don't know.
Here's why I think this is very
or it
dumb.
might be that just Baldwin decided because she got off the file that they're going to cut her a break. But I suspect that I suspect there's more to it. So
here's why I think this is very dumb. So you have violations of rights under 1983. So 1983 claim. Conspiracy to cause 1983. So these are civil rights violations.
Yeah.
Malicious abuse of process, intentional spoliation of evidence, defamation, violation of New Mexico Civil Rights Act. I am very curious about the defamation allegation here. So, do they have a claim? Can I go ahead and just say no?
I think you can go ahead and just say no. We can also play a sad song for Baldwin and his hurt feelings. This is a hurt feelings lawsuit.
Look at this. Look at this. Talk about not reading the fucking room. I'm sorry for this, but defendants must now be held accountable for their malicious and unlawful pursuit of Baldwin. Although no verdict in this civil case can undo the trauma the state's threat of conviction and incarceration has inflicted. My dude, you shot.
You killed a woman. Gun. Like, just chill.
You want to talk about trauma? Alec Baldwin has filed this action to hold defendants responsible for their appalling violations of the laws that govern their work. The remedy that he had was the dismissal of the freaking case.
Mm-hmm.
You ever hear the phrase, let sleeping dogs lie?
I mean, he's got some choices here.
So let me do this. I'm going to zoom. So tell me in your synopsis in 20 words what this case is.
Baldwin has hurt feelings and he needs a therapist instead of a lawyer.
But instead of hiring said therapist or in direct opposition to said therapist recommendations, he did what?
So what Baldwin is doing is he's suing for malicious prosecution and defamation. And the problem he has is that both of these things are insanely hard to establish. Why? Because you can't just establish malicious prosecution on the basis of your innocence. Even like plain innocence, like even where it becomes clear that they prosecuted entirely the wrong dude. Why? Well, because otherwise the court system would explode, because if they could never bring a prosecution unless they were certain, then they could never bring a prosecution, right? Because
side note, if you could file defamation against prosecutors for saying things that isn't true,
then, oh my God, the government would belong to like accused
plaintiffs.
Criminals. Yeah. It would be like, we actually have and this is Canada and the US, we have very strong protections against defamation for what is in a lawsuit, which is part of why you will see lawsuits make claims that you won't, like there's plenty of times when something will be claimed in a lawsuit that will not be ever claimed in a, outside of the lawsuit, right? Let's say I decide to sue Rob. I can be like, I am suing Rob because he intentionally did the most nefarious things I could think of. Mm-hmm. And that, like, the test for overcoming that protection from it being used for defamation because it's in a court filing, the test is basically go F yourself. And it's basically just you aren't going to overcome it in almost every circumstance, right? You have to show that the lawsuit was brought for, or that the case was brought, not just that it was a bad case, not even just that it was a frivolous case. It has to be like frivolous and like beyond frivolous. So in this case, even if, and the thing is that even if the prosecution's theory of the case is bad, like even if the court says, listen, you, like even if the court says, listen, your theory of how to convict Baldwin was never going to fly. Like that just there is no possible liability for, based on his circumstances. There's just no way. Even if the case was dismissed on a motion, like, a motion for a directed or summary verdict of just like, there's not enough here. That's still not enough to get you to malicious prosecution. You have to go. So it's just so far over this. And the other thing is, let's assume, arguendo, that he gets over the hurdle of the motion to dismiss. Let's assume he somehow gets to a jury trial.
This is my favorite part, because I was going to show this. That's this last part here. This last thing here that I'm going to highlight right there.
Jury you always say jury trial demanded, because you can change your mind on that.
But let's say hypothetically you get there. One, you're not going to put this in front of a judge because the judge is going to be like, too bad, so sad, get the hell out of here. Especially with a malicious prosecution case. When are you going to get a bench ruling on this? No way. You need to go in front of a jury.
But like, the jury's going to get a jury form. And one of the questions on malicious prosecution is going to be, do you think that there was probable cause to bring this case? And if the jury ticks yes, that they do think there was probable cause. The other thing is for defamation. Assuming defamation
don't do that. Don't do that yet. Don't do that yet. Don't do that yet.
Oh, I want to do that.
Wait, can we look? I'm going to look at the allegations on that one, because we don't have to assume. We can read exactly what's being said, and I want you to react to what's being said as I'm reading it.
No, I'm just talking about what's going to be on the jury form.
Oh yeah,
because one of the questions that will be on the jury form will be the defense of truth. And so the jury will have the opportunity to say, we don't think, if it goes to a jury, they will have the opportunity to say, we don't think Kari Morrisey defamed him, partially because we think that Baldwin was wrong in the killing of. And so basically he's like, dude, take the freaking win. Because now he could be doing the thing saying, this was they violated my rights and I'm clearly innocent and whatever else. But now he's putting it to a jury to possibly go, no, you're a killer, dude.
Yeah. So it is also different. It is also different for you to sue an individual just who makes a defamatory statement than it is for you to sue. And I don't mean to say this in a fashion, sue a lawyer. You sue a lawyer, especially a lawyer who happens to be as litigious as Kari Morrisey.
Oh, I mean, she's going to be down to fight back.
That's a choice.
Yep.
Now, let's go to this part, because the defamation is what I wanted to. I'm going to focus on this because you're going to break down the whole thing. But defamation cause of action. And you know what? You got to give it to Baldwin, because at least Baldwin's lawyers break down the allegations in a set where we can actually read the allegations in context of the individual counts. It's not just this massive recitation of facts, and then all of a sudden you're getting, I demand this. No, they actually do a good job of this.
Yeah, it is kind of, it is well written. It's just bad, if that makes sense.
Here's exactly what he was saying. Here's the problem.
It is the shiniest polished turd that you will find.
I think this thing is, it is, you know what? It's as shiny as this, which is plenty shiny, but do you really want it anywhere around you? No.
And it goes the same place.
Exactly. It does. Exactly. That's what I'm saying. So defendants,
I mean the trash, folks.
and Reeve made false and defamatory statements of fact concerning Baldwin, and to the extent any of their statements can be considered matters of opinion, such statements imply the existence of defamatory facts as described below. Okay, so here are the statements that they get to put on a whole trial about as to whether they were true or not. Statement 1, on January 19th, defendant Carmack Altwise appeared on CNN and discussed, quote, key pieces of evidence, end quote, with a reporter from the Santa Fe New Mexican. During the program, Altwise asserted that Baldwin, quote, had a duty to make sure the set was safe, end quote, and he, quote, should have checked that gun, checked those projectiles, end quote, falsely implying that Baldwin was responsible for Helena Hutchins' death. Well, we just had a whole trial that you escaped from, and I mean escaped.
And the thing is had a duty to make sure the set was safe is a legal that's so opinion.
That is 100% opinion.
Like, I could assert that Rob had a duty to check the ammunition on the Rust set, and that he should have checked the gun and checked those projectiles. And had Rob checked the gun, you know, she would still be. And none of that is defamatory because, like, it's all. Oh my God, that's all so opinion.
Yeah. January 19th, they appeared on Janine Pirro's program on Fox News stating, quote, "It was not a safe set," end quote.
Correct.
And asserting that it was Baldwin's responsibility to ensure the set's safety, again, falsely implying that Baldwin was responsible for Haley Hutchins' death. No. That one, I'd take issue with your drawn implication.
Yeah,
So,
I mean,
no.
they do a lot of quoting and spinning. And a lot of these quotes are massively out of context.
Yeah. I don't know how loud this is going to be. So tell me if it is too loud. Let me see. What's the master volume set at?
Oh, that's too loud.
No. You keep using that. Is that even audible?
No. If you were trying to make any noise other than your own voice, then no.
You keep using that word. I don't think it means what you think it means.
That was audible, and yes.
That wasn't too loud, right? Good.
No, that was... it's funny because me and Mrs. Runkle have been talking about Princess Bride for the past, like, 3 days, and here it comes.
Just... to say that it was not a safe set and it was your responsibility to ensure the set safety, I get to put on a whole case and a whole trial saying that that was a true statement. And not only that, but I get to call all the same witnesses. They get to testify about all the same conduct that did not make you look very good. So
Baldwin should really just have, like, this is absolutely the moment to just declare victory and move the hell on.
But you can't.
Oh, dude. Yeah,
I know. So this is the another allegation. Defendant also falsely accused Baldwin of deleting information from his phone, which she knew was false at the time. That's a whole lot of. You're gonna have to. How are you gonna prove that she knew it was false? How? During the same interview, said that the lab report confirmed that definitely the trigger was pulled, while omitting that the same lab report referred to testing in which the FBI broke the firearm at issue by hitting it repeatedly with a rawhide mallet without first inspecting or documenting the condition of the firearm. They're probably no.
You don't have to mention that.
That part. You don't. The result of the test.
Like, anytime, you don't necessarily have to say everything the other side might want you to say. Like, oh my God. And the thing is that destructive testing is not actually that uncommon in a criminal case, right?
And that's what I was going to say. Rachel Mills, and I just pulled yours up because I saw other people making the comment too. It's not a pointing to you. It's just a comment. State shouldn't destroy the gun. To the extent the argument is made that this was destructive testing or testing that is destructive in nature, I will remind people that this was immediately after Baldwin made the claim that the gun just went off, that he did not, in fact, pull the trigger. So the state had to test the firearm to determine if the gun could, in fact, just go off. And in order to do that, they have to subject it to some pretty torturous testing, which, yes, when you smack it repeatedly with a mallet trying to reproduce a firearm discharging by some accident other than pulling the trigger, you're going to hit it pretty damn hard. And when you're documenting the testing that you're doing, you're creating a record that can be cross-examined at a later date. Destructive testing happens all the time, and it is completely and entirely appropriate.
When have you ever heard of destructive testing of a gun? I have run multiple cases personally where a gun has been tested to destruction. And let me tell you, the simplest and most common potentially destructive test that you can do on a gun. There is a test that is very frequently done with a firearm that is potentially a destructive test. And it goes like this. You take the gun. You remove the magazine from the gun. You put a cartridge into the magazine. You put the magazine back in.
Yeah.
You
and
rack
you
the
fire.
slide to chamber the thing, and you fire the gun. Firing a gun is potentially a
Potentially
destructive.
destructive.
Because the number of times I have seen we fired the gun and it blew up is more than I have fingers. And that's even though I never do that test personally while holding the gun on a suspicious firearm. But you get there a lot faster if you do the tests in your hand. But
yeah. So
like,
to make the statement that the trigger was pulled, like there's no way this firearm could have gone out without the trigger being pulled.
This rawhide mallet test is a known test. It is done but like anytime there's a question of whether or not the gun was fired by some sort of impact or bump or whatever, they will use this. And this is a potentially destructive test. They don't
who's
necessarily
having issues right now
break it
with discharges. Is it SIG? Whose handguns right now are discharged? Like I was reading a report about this.
I think you're onto the Baldoni lawsuit now.
No, oh God, wrong. Yeah. Very, very bad. No firearms. Bad.
Yes, SIG has had that. There was some issues with a particular. SIG has that on one particular gun. There were some issues on that with a particular Ruger at one point.
Yeah.
It happens that sometimes they make a gun that's got those problems.
Hypothetically, I want to sue SIG after one of these discharges occurs, right? One of the tests that needs to be conducted with regard to this particular firearm, if I'm going to sue SIG, is whether this firearm can actually discharge a projectile in a fashion that's being alleged, which actually results in me smacking the damn firearm repeatedly with a mallet because I have to try and replicate what happened.
Like, this guy didn't invent this test. This is a test that is well known in the literature. And there's other similar tests that you'll see. Like, for instance, if you've got, if you've got somebody, let's say that, like, me and, Joe go to my garage and Joe ends up dead, right? There'll be,
well, that's unfortunate.
And they come in and they say, like, what happened? And I said, well, I loaded the gun. I was showing them how you load the gun. And then I dropped the gun and it went off. Like, it hit the table and it went off. And Joe, like, so what is the first thing they're going to do? They're going to take this gun. They're going to load it with blanks.
Is this possible?
And they're going to drop it a bunch. And they're going to try that. And then they're going to break out the mallet. And they're going to
want them to.
This happens. This happens all the time, right? This is so much a thing, right? And if somebody says this gun goes off, because there's a historical case where a lawyer managed to do a great job for his client. He got his client acquitted because his argument is this gun is such a piece of garbage that it goes off without somebody pulling the trigger.
Yeah.
And it wasn't in the courtroom, it was in the back room. He was showing this gun to other lawyers when it went off, and it shot the lawyer who was arguing the case, and he died. And then later the original guy who was accused of murdering somebody with that gun was acquitted because it's like, yeah, clearly there's some evidence that this thing goes off when you don't, like. That is the stupid way of testing it. You don't want to shake the gun until it goes off into your gut and you die. Instead, we do this test. It's a known test. It's a thing.
This is part of the point that I'm saying is this testing was done after Baldwin had made the allegation. So Baldwin came out and made the story of, the question was he pulled the trigger. Then he came out and said, I did not pull the trigger. That was part of his defense. So what did they do? They went and tested his damn defense. They did exactly they tested his damn defense.
They could have done, like, it might have been better to invite the defense to be there.
There wasn't a defense at that time, was there?
I mean, even if he's self-represented at that time, you send him personally a letter.
But why? You don't have to do that. You're the custodian of freaking evidence. It's your case.
I mean, and it might have been better if they took pictures of it. These are all things that they could have done better, right? And the problem is that the problem is fundamentally that how do I put this? If every police investigation had to be done correctly or it couldn't proceed to trial,
Oh my God.
you could
Oh my God.
could close down the prisons and just have an elevator that doesn't open from the outside, because the maximum occupancy of that elevator is 8 people, and we would have fewer than that in jail at any given time, because so many investigations are sloppy or done improperly or some fashion of whatever. And I mean, let's consider some other forms of destructive testing that you might see. Let's say Joe they go into his house and they find a kilogram of a white powder and it's next to some scales and some cash and like a bunch of handguns. And they're like, I wonder what white powder this could be.
And they
that is measured out into a kilogram block. So what they're going to do, they're going to chip like a gram off this kilogram. They're going to put it in a baggie and they're going to send it off to the lab. And the lab is going to destroy that kilogram in the process of testing it.
They're going to dilute it.
Or not the kilogram. They're going to destroy that gram. That gram is going to be
They're going to put different chemicals into it. They're going to change the substance of it, the material composition of it. When they test for blood and they're putting the luminol on stuff, the luminol is tainting and coloring the shirt that's in front of it. Every bit of testing is destructive. Now, here's the difference. People are going to say, well, what's the difference, Karen Reed? The difference is you document it.
Yeah.
And you go about recording everything. And the FBI does a lot of stuff shady. I will tell you one thing they don't do shady. They record the hell out of everything.
And that's the thing, is this guy should have done better about taking pictures of the parts beforehand. But even if he had, it wouldn't have mattered. Like, Baldwin's team would have been like, oh, well, how can we tell if we didn't actually, it's like, okay.
So it gets so much dumber, right? And I mean dumber in the terms of defamation law. On January 19th, defendant Reed commented on Baldwin's ultimate guilt. That sounds like a pretty big effing opinion statement, stating he is somebody who committed a crime.
Also, I can guarantee that applies to every human on the planet.
Yes.
Rob is someone who has committed a crime. You know how I know this? Because it is impossible not to.
Correct.
Like, okay.
Everyone in the chat, every single person in the chat, you have committed a crime. Absolutely, unequivocally, you have committed a crime. Criminals, all of you. Deviants and criminals.
It's just
statement. Also opinion.
Yeah. Most crimes no one cares about. But, like, let's imagine that, like, I go and I make a surprise trip to see Rob, and Rob doesn't know I'm there. I, like, find him at the courthouse, and I go and I pat him on the back to get his attention.
Battery.
I've just battered Rob. Is Rob going to be like, I'm pressing charges? Almost certainly not. He's going to turn around and go like, Ian! And I'll be like, guess which tie this is? And he's going to be like, I know.
And,
but
a very long, big hug and people laughing and people wondering why these two gentlemen are laughing and joking outside of a courthouse hugging. It's very confusing, but it's true.
You just ought to...
These are not actionable statements. They're not actionable statements. I understand also, people having...
Even if they said specifically that he committed a crime by killing... that's hugely opinion. And also, even if they're legally wrong, you're now into the question of how would that statement ever get you past like actual malice?
Privilege?
How are you going to prove?
Also litigation privilege. We haven't even gotten there yet.
Well,
there is privilege.
It's all the walls.
We know from the FBI report that he pulled the trigger. That was the position that was offered at trial. He did. I'm sorry. He did. I know. I don't care. Mr. Baldwin, you want to sue me? I know based on I can make a pretty damn clear inference based on the evidence that was adduced at trial and the reports that were adduced at trial. This gun did not just go off in your hand.
Yeah. The theory that he didn't pull the trigger is, in my opinion, because, oh, right, that's what that kind of statement is it's an opinion, is complete dog shit. Like there's, and you can hear Zora's got all the opinions about this. But
I mean, here's the thing. I will call it, because here's the other part about this. Let me go this one step further. I will say that it is factual. I will say, as a matter of fact, Alec Baldwin pulled that trigger. Right? If I make that contention, you know what Mr. Baldwin has to prove to win a defamation case?
Like, I could fill a phone book with a list of things he has to prove to win the defamation case.
Just that statement that it is a fact that Alec Baldwin pulled the trigger. You know, he has to prove.
The other side. Yeah.
The other side.
Yeah.
He has to prove as a matter of fact that he did not. And you cannot with this evidence. That's not Leo. That's not my dog. That's Zora.
That is Zora. So we're celebrating, and also I as part of my Christmas gift to Mrs. Runkle. Mrs. Runkle really likes a sauna, a proper sauna.
Ooh, nice.
So I rented one. And yes,
Mischief, you better not be listening to this fucking stream right now.
We're having some guests over to to enjoy the sauna with us. I'm gonna have to step out in a bit to go and also join them. But Zora is a pandemic puppy. She did not get as socialized as we would like. And so whenever Zora encounters somebody who isn't super familiar to her, she has all the opinions about whether or not that person should exist.
Or they should be petting her. Or
no, she does not.
Her. Oh, she does not like people?
She does not like people she doesn't know. So, yeah, she, what is it? She just is like, who are you and why? How dare you be a person who exists? And I'm going to bark at you until you decide to stop.
I mean, that's one. Leo's mentality is, I'm a big, scary looking dog. I'm going to bark at you because I want you to pet me. And I think that by barking at you, being a big, scary dog, you're going to come close to me and pet me. I keep trying to tell him that logically that doesn't play out, buddy. You have to not bark and they'll come and pet you. He doesn't understand that part, though.
Zora's getting better. There's a few people who come over a fair bit who now she she'll understand that those are good people. But it is, it is kind of a tough, it's a process. So that is people arriving. I don't know if the sauna is yet up to temperature because it is not an electric sauna. It is a wood-fired sauna. Mrs. Runkle is doing the wood firing right now.
This is going to take a minute. Okay, so we've got to fly through this so that we can get you to your sauna date. In national media appearances, defendants repeatedly stated that Baldwin was facing many years in prison, even though if convicted of charges, maximum sentence 18 months, implying greater criminal culpability and even more severe criminal act on Baldwin's part. Not defamation per se. I don't think that's an actionable statement. Go away. The day before charging Baldwin with 2 alternative felony counts, the evidence of the facts speak for themselves. How's that actionable? Wait, hang on. That's the claim? You're really? Really? Legitimately, the claimed defamatory statement is the day before charging him, the office posted on Facebook, the evidence and facts speak for themselves. Okay.
Wow.
Sure. Why not? Then we've got the motion to disqualify. That sounds like just differences of opinion in the law, which we argue about in court all the time. Oh, another day, another motion from Alec Baldwin and his attorneys in an attempt to distract from the gross negligence and complete disregard for safety on the Rust film set that led to Helena Hutchins' death. Point out the lie. Someone here, point out the the lie in this sentence. Please. I'll wait. Everyone, even the fancy celebrities and fancy attorneys, are held accountable to the law. These are not defamatory statements. Why are you doing this here? And here's why this is driving me insane. What he is doing is now he's inviting an entirely separate civil case. Here's how this plays out. If this gets beyond a motion to dismiss, which I don't know that it will, and I don't know what counts will, because there's a whole lot of immunity claims that need to be brought here. And I mean a whole lot. I think this is going to get thrown out on the 1983 claims. I think a lot of this stuff gets tossed on motions to dismiss. I don't think a lot of this survives the day. I really don't. Now, Luke Nikos is the one that signed it, and Spyro is the one that's also co-signed on this. I don't know what they're attempting to do. I don't know if they're trying to get a settlement. This sounds like a PR stunt, because there's no way that these two lawyers want to bring this damn thing to trial. There's no way, no chance. Because bringing this to trial means that they have a burden to prove that everything that was done as to Mr. Baldwin was malicious, had no basis in fact, was absolutely no probable cause founding it, and the statements made were 100% factually inaccurate. In response, the entire team of lawyers that are being sued get to put out their entire case, the entire prosecution, yet again, and lay out all of the missteps, all of Baldwin's behavior, all of him ignoring things on set in broad detail, because now they're on the defensive. They get to pull all of these things out.
Also, several of the people who are named in this are going to be covered by, like, in terms of their legal fees, who's going to pay them?
The county.
The government.
Yeah. Everyone.
Because
every one of them.
Yep. So there's going to be a whole raft of lawyers on this. And it's going to be exciting. It's going to be interesting.
This is just a you had what you and I perceived to be the win of, honestly, the win of the decade. That thing got tossed.
It was lucky. It was, I mean, his lawyers did some good work. It's, I could tell you, I would be looking at this going, I have no intention of messing with this decision whatsoever, because it's like if you win the lottery and you show up at the lottery office holding your winning ticket and you're like, I demand a recount.
Yeah.
I demand that you check. This can't be right. And they're like, well, we just have the bag of money to give you, sir. Would you not like the bag of money? And it's like, I demand you check this first. And it's like, bag of money, though.
And we covered, I mean, you and I have followed this trial. We followed this trial, and I think Alec Baldwin's defense was, I don't know, non-existent with regard to some of his conduct, because it still didn't get me beyond, you were the one that engaged in the behavior that was not safe. You did this. I know that there's a whole lot of excuses you want to rely on, but no, the law doesn't allow you to rely on those excuses, which is why we had a trial. And because of a technicality in the way the evidence was handled, and I agreed with the disposition by Judge Summer. I agreed with that disposition. I don't think you could cure the defect that was made. I agreed with the dismissal. It sucked. It felt bad, because it felt like there was a wrong that happened that there should have been some form of punishment for. And honestly, both factually and legally, Alec Baldwin should have faced culpability for that conduct. So it felt wrong.
Here's the other thing I just look at when, like, I look at the the filings to dismiss, right? And the press conference or the press, statements that were put out.
The
And it
setup.
seems to me that Helena's family, not Hannah's family. Who cares about Hannah's family here? Helena's family seems to be very much on Morrisey's side. And there is a very real possibility that Helena's family ends up making some sort of statement in support of like Morrisey or in opposition to Baldwin. And I'm like, would you seriously, is this seriously something you want to poke?
You don't. This is fucking gross.
Just let it go, dude. Let it go.
Think about the opening statement you would get to make in defense of this defense against this lawsuit. Just think about that. Think about what you'd be able to say. Think about your closing argument, what you would be able to say. That this man was standing behind the firearm that discharged and killed Helena Hutchins. Take all of the disputed facts aside. What is completely undisputed and acknowledged by both sides, the individual filing a lawsuit for malicious prosecution was holding the firearm that discharged and resulted in the death of Helena Hutchins. And he has filed a lawsuit claiming that he bears zero responsibility in any of that. None. It ain't me. I was holding it. I was the producer. I was the director. I was these things. I have zero responsibility, and damn you, and I will sue the state of New Mexico and all involved for even implying that I had something to do with it. And you're arguing this to a jury in New Mexico.
Yeah, soon.
Good luck.
Yeah, I don't see it.
All right.
Before I go, can I send you a link to something horrifying?
Oh no. What is that? Is it worse than the horribly shaped pickle buddy?
Yes.
No.
It is arguably a horribly shaped pickle buddy.
Oh no, I saw this.
Can we run that?
Yeah, I hate you for it though. Let me see. Let me see if I can't get the show in a somewhat normal setting. Oh my God. All right. What, Ian? Hey, can you hang on and answer if there's any questions for you, and then we can show this terrible thing
yes,
like as you're
100%.
Leaving? All right. Cricket S, I tagged this one. Could it not be argued that is the armor responsible for the bullets and not the actor? Yes, he pulled the trigger, but those bullets were never supposed to have the ability to harm anyone. We talked about this extensively.
Can be responsible.
Exactly. We talked about this extensively during the trial and leading up to the trial. When it comes to a firearm and the handling of a firearm, responsibility, and even the actor's training tells them that you are the one holding this firearm. You are responsible for it. Like the training manuals say it. We pulled that up. So there can be several people responsible for something that results in the death of somebody else. Remind you, Helena Hutchins, or not Helena Hutchins, Hannah Gutierrez Reed, misconstrued my people there. Hannah Gutierrez Reed was prosecuted and convicted for her role in this. And honestly, I knew that was going to happen, but also you don't get to just put 100% of the blame on somebody else when you are sitting there holding the firearm at the end of the day. You hold a gun, you know it's a gun. It's a gun. Period. Unhinged Honey Badger, someone breathes. Zora, what did you just call me? Probably accurate. Becky G, shiny like ice cream, SpongeBob. Oh, it's bad. Just because. But Rob, he was so put out that he didn't get off without actually having to pay anyone. What? Terrible. What a terrible idea.
Mhm.
Mr. Baldwin, you just put yourself right back in the center of a spotlight that you had tried so hard to get out from under. But, you know, I hate to also say this, but did you happen to catch that little clip of Hilaria Baldwin that was circulating the internet?
There were several.
I don't know what this is called. I forget. You know, it's just the.
Oh, where she was like
Ay, ¿cómo se
pretending
dice? ¿Cómo se
to know what
dice?
an onion is.
¿Cómo se dice? Cebolla in English. Cebolla. Onion. Lady, you were raised in Massachusetts. I'm not a fan of Alec Baldwin, like in the least. Yeah.
Was she really raised in Massachusetts?
Yes.
Oh man, I was willing to give her, like, sometimes I have been unable to remember the name of something stupid, but onion?
Fucking onion. It's an onion.
Yeah.
Sherry and Max just hit me. May will be the 3rd anniversary of YouTube meeting, right? That's correct. Can we mark it by watching a video of that night, please? Oh, that'd be fun.
That would be a fun. I think we could make that happen.
Can't we find? We should find the live stream where you came home from court and I had the 200,000 thing up on 100,000 thing up on 100,000, right? Up on the.
Yeah, that I was so tired, and I come up and I'm like, "Oh, that is so awesome."
Put the sign on the door. We got to find that video.
Yep.
That would be fun. That's a great idea. Thank you, Cherry and Max. That's awesome. Oh, H Scorpio, did you cover the Bad Dragon suit?
Wait, there's a Bad Dragon lawsuit?
I did not, and I did not know there was a lawsuit. Ian, that sounds like a Monday fun day.
That's a Monday. I think I'm finding that Bad Dragon. Like, was somebody injured by a dragon being overly bad?
No.
Oh no, Ubisoft sued.
Why?
So
trademark for what?
Wait.
Ubisoft, the game company.
Wait, what the hell? How does Bad Dragon fall into this? Okay, action taken against Ubisoft by disgruntled players for deleting the crew. It doesn't seem to involve Bad Dragon itself, so I don't know what that is about. There is Bad Dragon suing some people. Bad Dragon versus Sin Saint. Bad Dragon. Now you got me down. I can't say when we're talking about Bad Dragon. I cannot say this phrase.
Do not say the word. Don't say
rabbit
the phrase.
hole.
You cannot say the phrase. Not after you say the word Bad Dragon. Nope. Those of you wondering why the Bad Dragon thing, Bad Dragon call them prosthetics, prostheses for like larger versions. And I mean, larger, I mean like 1,000 times larger than this. That are intended for.
I just pulled up the lawsuit, or one of their lawsuits. So their case states, as they describe themselves, this is how Bad Dragon describes themselves. Plaintiff is an industry-leading developer, manufacturer, and seller of adult entertainment products, including its extensive line of fantasy-themed S-toys. Plaintiff has obtained numerous copyright registrations for the unique original sculptural design elements embodied in many of its S-toy products, including those at issue in this action. Recently, plaintiff discovered the defendant just directly copied at least 13 of plaintiff's copyrighted products and has been selling substantially similar products that are copied from and derivative of those copyrighted products.
Wait, no. Who did they sue?
A company called Sin Saint Incorporated. And I am downloading the hell out of this. Folks, this just got added.
This is a sex toy. I'm gonna say sex toy. This is a sex toy copyright patent.
Yes.
This is
yes.
This is sex toy IP. This is not real. This is sex toy IP.
Yep.
Well,
we're gonna cover this on Monday because and this is gonna be after the 2-hour mark. It's gonna be after spicy time because
hey Scorpio, I'm not casting any shade on you setting that super chat, and I share that is an appropriate use of the super chat power. Oh my god. It's a sex toy IP litigation by one of the companies that makes one of the most insane sex toys in the world.
Now there's also somebody sued them, and I want to find that because it also looks wild because they sued them on a
while you find that, let me play something for the chat, because the question was asked for the chat on the Hillary Baldwin. This is the clip.
I learned this from when I was a kid. Yeah. Don't look it up online because you'll learn something different. But I learned this from when I was a kid. Then he learned it.
Okay,
but I made it before.
Hold on, Elaine, please explain what your.
I mean, I don't know what that one is, but I can tell you that my tortilla
so rude.
is potatoes. You have to not cut them too tiny because they're not going to have the right texture. And then my husband hates cebolla.
Onions.
I forgot it. Okay.
Cebolla.
So he hates cebolla. And so I grind cebolla and ajo together. And we put like a little bit of olive oil in it to like mix it really good. Then we put oil in it just to like see it, look at, I don't know the exact quantity, but it's like that. Then you mix it around and then you let it get to be soft.
Yeah.
This situation is like a fried potato situation.
Yeah. David, please explain yourself.
That will take the whole day to make it. This is just 30 minutes.
Cebolla.
Onions.
I forgot it. Okay.
Cebolla.
My husband hates
Ready?
cebolla.
Onions.
I forgot it. Okay.
Cebolla. I forgot it.
Wow.
That's a real clip. That is not parody, folks. That is not parody at all. And yes, she grew up Hillary Baldwin, or Hillary. Like that was her name growing in Massachusetts. That is not she. So you were looking at the other bad dragon. Oh my God.
Apparently they got sued under the Americans for Disabilities Act, but I'd have to pay to get it. So I'm like, I don't know. Yeah.
Wait, hang on. Bad dragon. What? You got sued under the ADA?
Yeah, and apparently it was settled, and I don't know how it was settled.
What's
but
the claim?
I would have to pay money to get it, and I don't know if I want to. Do I have to pay to?
Wait, is it Pacer?
Yeah.
Send me the link.
I'm logging in.
You don't have to. Just send me the link.
I'm just grabbing it here. It's going to be $140. Let's grab this. All right. Violation of the ADA. I mean, it might be just something like that he was working for
employment dispute.
Oh, it's a web page lawsuit.
Lame.
So, guys, the ADA requires that you take certain things, and so one of the things that happens is people like the ADA gives a private cause of action for violating this. And so what you'll end up with is there'll be people who will look around on the internet and they'll find a web page that doesn't properly handle, screen readers, and then they'll sue.
Reads.
Yeah. And some of these, I'm not saying this guy, some of them are kind of professional litigants. where they basically just look for that stuff in order to bring the suits. But I don't know if this guy is, or if this guy was just, maybe this guy really wanted to buy a very realistic horse dong. And, you know, it was really sad for him that he could not do that because as a visually disabled person,
pulling
it was...
this super chat up during this discussion for this reason, because I know this individual would have absolutely died laughing. That was very bad choice of words. He would have laughed so hard that we would have died laughing. Off topic, but I have my first drink out of my Law Rex glass. To you, Jeff. And in your honor, we're talking about the Bad Dragon copyright, possible IP litigation.
There's not enough cannibalism in the Bad Dragon case, though.
Not nearly enough, Jeff. Cheers to you, my friend, wherever you are.
Due to defendant's failure and refusal to remove access barriers to its website, plaintiff and visually impaired persons who need screen readers to access websites have been and are still being denied access to defendant's website and the numerous goods and services and benefits offered to the public through the website.
Oh my God. Oh my God. That's a lawsuit. Someone filed a lawsuit saying they wanted the website to adequately describe and read what they were seeing on the website.
He's like, I cannot get a silicone dong the size of a Coke bottle. And I'm not talking, I'm talking like 2 liter here.
2 liter. 2 liter. 2 liter.
Man, that's
Mrs. Squirrel. This was the phrase we're not allowed to say. we prohibited this statement.
They do, I think, sell something like that on their website.
Before I kick your ass off the stream. Oh God. Oh no, Lady Fang. At least can buy the Hulk Hogan one from that. Nope. We need to change topic. But I can't all the way change topic because you insisted on one final moment of immaturity before you go in and partake in your very well-deserved celebration. And it was this.
And you're gonna have to maximize that so it can be seen, or the video there.
A tech firm, I will maximize video. I'm going to read this out loud. A tech firm releases a life-size AI robot girlfriend that can, quote, express emotion, end quote, and talk to you for the, quote, affordable price of $175,000. The robot, Aria, my apologies to anyone in the chat that's named Aria, says
made a bad life choice today.
Interested in meeting Tesla's Optimus robot. Oh my God. Realbotix CEO Andrew Kegel says, that sounds too much like another word that I can't.
Oh, Rob. Oh, that's hilarious.
Oh my God. Okay. Andrew Kegel says he's trying to make robots that are indistinguishable from humans. By incorporating advanced motor technology, Melody enhances movement fluidity, modularity, and interaction, making her a versatile option for a variety of applications. What the fuck are you talking about? What applications? No.
Oh, I'm betting that the guy, the CEO, has tested some of those applications.
Melody is created with the intention of having robots that are easy to travel with. You gotta put her in an airplane and sit her next to you. Modify for various forms of personal interaction.
Honestly, I'd be more comfortable sitting next to a guy who had an actual bomb on the plane.
You know what? I would sit next to this thing because it would talk less.
I don't know that that's a fair assumption, but yeah, I mean,
The robots were on display at the 2025 Consumer Electronics Show, the CES show in Las Vegas. I am so nervous for this.
Oh, let's see what the robot girlfriend of the future looks like.
Am I turning the volume on?
Yes, you are.
I don't like you.
This is Aria. So this is our flagship humanoid AI-powered robot. She's highly realistic.
Highly realistic? Oh, wait, hold up.
Oh, you got to show the highly realistic. You got to show that.
She has her own social media, so she might be competing with you one day.
Yeah, she's totally going to put me out of
no.
business.
No. Oh my God, this is not real. Asking the AI robot's going to take our job. Wasn't there a South Park episode on this topic?
Can you replace humans for jobs?
I'm excited to be here. Darling, I'm more about enhancing human experiences rather than taking jobs.
The thing is, I'm pretty sure that the owner on this one does intend for this robot to take at least some jobs that no one else wants to do. Because if you're spending $175,000 for this, this has got to be your last ditch hope for certain jobs to be done for you.
For those of you who couldn't understand what she was saying, I'm more interested in enhancing the human experience than taking jobs. Just take that as you will.
Think of me as your entertaining plus one.
She's not trying to replace humans. Just be your.
Oh my God, this is
so
incredible.
Oh, and then look at the hand shape right there.
Nope. Nope.
Drive around, full body, 175,000. Moving base. She's not walking, but she can move. She can drive around. Yep, on a Roomba base. She has.
On a Roomba base. Does it also vacuum?
Oh my God. This is horrible. He created a vacuuming sex robot. Oh, I feel like we've gone backwards so many years.
This is basically like if you want the experience of like a woman who is on the nod, because like when she's making that weird head shape, it looks like she's so dosed up on like, you know, some sort of opiate that she's like on the nod. I'm going, wow, this is the worst. So anyway,
I did not expect like trauma coming from
now,
this.
We have to tie this into the legal issue because at some point there is going to be a product liability lawsuit.
Oh no.
When that thing mangles somebody's
it's gonna do a Lorena Bobbitt.
It's gonna make relish out of someone's pickle. And
safety precautions and the liability and the litigation, and is it a jury trial? Oh my God, I hope it's
jury trial demanded. And then you have to sit there and explain, I spent $175,000 for this
the lawsuit gets filed. Motion to seal all proceedings. Jury trial denied. Jury trial refused. Jury trial expressly refused. Please God. Oh my word.
And the thing is that this is multi-purpose. It's got the purpose they're not telling you it's for. It's got the vacuuming purpose, apparently, because apparently it's a Roomba. And on Halloween, you can use it to scare children.
Apparently the vacuuming purpose is a dual purpose. random comment there. I can only pull up like 1 or 2 of your comments, bud, because YouTube algorithm is going to be YouTubey.
But on Halloween, you could use it to scare children. Also, this is the comment that wins the day.
Oh my god. And this is where we learned that humans are not capable of actually using robots for a productive purpose. Well, it's productive just for the wrong purpose.
Yeah. So
just I hate you so much right now. I am so like joyously mad at you. I don't know. That's an oxymoron. I get it. I'll deal with the oxymoron later, but what the
also, you know, they're going to make
lawsuit.
these things that look less horrifying, slightly less horrifying, and you still know that there's going to be somebody who drops $175,000 on one of these.
On this one.
And you know that at some point it's going to show up in a family law case where it's, I don't want the kids to go visit their dad.
I do not need this case.
Because their new girlfriend is the horror robot from Uncanny Valley.
You know, please, God. Please, I know that I have screwed up a lot of things. I know that I try very hard. But in my 2025, I do not need my spouse cheated on me with a robot case. I don't need it. I don't need it in this year. Give me at least a year to process what this could entail before you send one of those my way. I agree with Ian. It's going to happen. But dear God, just hold off for a few minutes. I'm not mature enough to handle that litigation right now. Have I been practicing for 15 years? Yes. Am I mature enough to handle that? No.
All right. So, folks, you have heard Rob's goals for 2026.
Do not get a sex robot case.
No, that's for 2025 is do not. 2026 is when you want it to happen.
No, that's not that does not mean the opposite. No, those two things don't go that way. So give me at least a year. God can give me 5 if he can. 5 or 10. Hell, I don't ever have to have one of those things.
Anyway, that robot is still the what do you call it? The best of the candidates that are running for the Liberal Party of Canada.
You know what? I will give you that one. I've seen some of the reporting. So you know what, Crazy Cat Queen? You guys actually make me do this fucking thought exploration. Oh my God.
And at this point, I'm gonna go hit the sauna. Rob, now that I have dropped this in your lap, you have a great time. Drop this in your lap being entirely metaphorical because I don't think you actually want one of those in your lap. That would be
nope. Not at all.
All right.
Nope.
Good night, everybody.
Have fun. Good night.
Cheers.
Oh, fucking Ian. Oh my God. Now I'm thinking about litigation with a fucking robot involved. Crazy Cat Queen, actual question. How would cheating with a robot case be any different than watching too much corn case for divorce? Honestly, it'd probably be substantially similar. In arguing that, I don't know how I would argue that. I'd probably say that if you use marital assets to purchase the damn thing, $175,000, that should be considered waste of a marital property, and try to argue that. Lux Leather, yes. That is exactly what Ian, my purported friend, just did. He's going to mic drop on a horse dog and a robot girlfriend. That is what he did. Sorry, just taking a quick note. Okay. Sorry, folks. 1 second. Just had to do some back channel stuff. All right. Here come the chats. Please send an EDB. Which one, the Bad Dragon or the robot? Because I can send her both. I imagine she would bring up at least one of those lawsuits at some point. I'll probably text her about that. Anyways. Sibling creature running behind, but someone point out the lie in that sentence. I can't help thinking you need to the Jeopardy theme on your soundboard. That's not a bad call, sibling creature. I probably should add that just for the long pauses that are intentional. Commenter. Cannibalism, nope. Implied bestiality, maybe. Nose, Pope, I not sure. This one actually caught my attention. 175,000, still cheaper than marriage in the long run. I imagine that there are some people who are, after having a messy divorce, weighing those numbers. I really do. And that is why my judgment threshold isn't all the way up here. It's because I've seen a whole lot and I'm going, people want to do their thing, they do their thing. Just if they could respectfully not involve me in it for a little while, be very much appreciated. Very much indeed. You can safely put in a suitcase. Oh my God. Just because she will not take jobs, but she will give. We're going to get through the immature comments quick because, oh my God. I can't. I really can't. It's a fucking sex robot that is not realistic and looks scary and creepy and like it's out of a horror movie. What? It runs around a Roomba. Why? Brit Flip will once trade cattle for robot arranged marriage. These are a lot of really strange questions. Cad Monkey, pretty bad when your robot girlfriend scares the dog. And I imagine that would happen all the time because dogs hate robots and vacuums and robots on vacuums. Sardinisms, AI girlfriend, it's productive. It's not just for reproductive. Yeah. All right. Ian Paler, Far Cry 3, Bad Dragon. Interesting. That could be the copyright litigation in the Ubisoft case. Jet J, Canadian living in Florida. Enjoy the show and stay warm. Thank you, Jet J. Much appreciated. Lazarus. Hey guys, I found out yesterday that I passed my last licensing exam, so I should soon be a new Ontario lawyer after character and fitness is done. Congratulations, Lazarus. Way to go. Welcome to the phenomenal practice that is the law. Hopefully, after the last 45 minutes of this discussion, you have not been running for the hills. Hopefully. Ray Eichler from Texas. What is all this white stuff on the ground? It's called snow. Precipitation that freezes on the way down. And believe you, Texas does get snow from time to time, even the warmer parts of Texas. Megan, aka Meg, is autistic. My area in Australia had temps ranging mostly between 29 Celsius, 84 degrees Fahrenheit, and 39 Celsius, 102 Fahrenheit over the last few weeks. Feel free to send some snow my way. Megan, if I could, I very much would. I'm just about snowed out. I would like my cases to go forward, and I'd like to not be delayed in my travel to and from my office because, very good reasons. Improv man, he's trying to keep prey from knowing he's there. Oh, as to Leo, is that real? So Leo burying his pee in the snow. So people were asking this question. I asked the question rather emphatically about what my dog is doing in this particular clip. Share so I can see here. I asked the question what my dog was doing here because he's looking at his snow on the ground, smelling his snow on the ground. He's going, I don't like this. And he goes, I'm going to find some snow and I'm going to cover the snow that has the yellow on it. And he goes, do it with snout. Yeah, cover that, cover that, cover that, cover that. Interesting. Huh. Oddly enough, that makes really good sense. Thanks for that input. Really appreciate that. Let's see. Megan saying Australia's racing at the moment. Yep. Saw your other chat. Oh, a Dexter. I'm in Richmond, just happy to have running water. Yes, Richmond had a boil water warning, and I'm glad they finally got water restored. In weather like this, and you don't have running water or potable water, that's a big problem. Richmond had that problem for the past few days, so I'm glad that they got that restored as well. Kristen, M96, isn't Leo's Gotcha Day coming up? It is indeed. Don't know how to celebrate it. Give him a TREAT. This dog knows more words than I could imagine. You say one of the kids' names and he goes immediately searching for the kids. Knows all the words. Like he's too smart for me. Way too smart for me. Excuse me, BA in history, program manager in IT. Change is okay. Change is absolutely okay. RN Rome GA, new member. Thanks for becoming a member. Canonical Heat, thank you for gifting memberships. Also, guys, if you're watching the stream, please hit the like button if you wouldn't mind. It's really easy. Little button down there. Click it. Very easy to do. Just Because, thank you for the gifted memberships. Becky G, thank you very much. Sandy, thank you for the gifted memberships. Shell C, thank you for the gifted memberships. Christy Robinson, my dogs are afraid of mops. Dogs, they're afraid of all kinds of stuff. It happens. AEG, enjoying the stream tonight, might have to leave the company I've been working for a year. They brought in AI to do draft transcripts, and it's made my job both harder and slower. AI transcription is not yet there. And honestly, there's a bunch of questionable words where they don't have the software to go in and actually correct it as easily. So I appreciate court reporters and transcriptions being done manually because I like the audio tape being listened to by an individual and I can correct it with an errata sheet. That's very much appropriate. A Hedinger wrapping the girlfriend back to Dragon. Furry version might get out of the uncanny valley sooner. Oh my word. Yeah, we ended up there. That's where we got to. So, with all of that in mind, shall we shift a bit of our focus? I don't know how to say with all of that in mind, shall we shift focus? Because that doesn't seem like the appropriate transition. But it's what I have. So we're going to go with it. Actually, you know what? We'll do this. Social media itself brings us a whole lot of negativity in our life. Sometimes it brings positivity. Sometimes it ends up at the forefront of litigation. Sometimes social media itself, including social media companies, ends up in the crosshairs of Congress. And when they do end up in the crosshairs of Congress, they have the ability to file lawsuits to fight back, especially when the content arguably restricts the speech of both the company itself, the owner company, and several individual and creators who create content on the company. So social media, while it gives us terrible things like a visual into the future, which perhaps includes AI robots riding around on Roombas doing any number of things, it also brings us the ability to share experiences, share information, share news, share all kinds of stuff. Hell, we're talking on a social media platform right now. So let's swoop to our next topic. We'll do a double swoop just to clear the air of where we were. So moving forward, I had this on the radar, but I had forgotten that today was the day of the oral argument. So, emergency application for injunction pending Supreme Court review. Filed by and on behalf of TikTok Incorporated and ByteDance Limited. Applicants who were petitioners in the lead case in the DC Circuit Court, TikTok v. Garland, are TikTok Incorporated and ByteDance pursuant to Rule 29.6 is a wholly owned subsidiary of TikTok LLC. It's just a bunch of privately held information. So, where are we? The DC Circuit's opinion and judgment denying petitions for review entered December blank. This is what we're appealing. Table of contents, question presented. What is the question presented? So page 6. No, 6, actual page 6, not page 6 of the damn indices. Page actual 6. Give me the question. Whether the act asking and requesting TikTok to divest, or ByteDance to divest any ownership interest in TikTok is itself unconstitutional as applies to TikTok and ByteDance Limited because it categorically and uniquely prohibits them from operating the TikTok speech platform and other applications in this country. The opinion that we're appealing from, the DC Circuit Court's opinion, is available here. They ordered, denied the injunction pending Supreme Court review. Okay, jurisdiction, there we go. Statement, speech platform, we're not going to get into that. We're going to let the oral argument speak for itself. So, we are going to do my place and my link. I just realized that I had my I'm starting late thing still pinned to the top of the chat. So here's what we're going to do. We reviewed that part. I want to pull this up real quick. And then I may have. So here's the facts of the case. TikTok is a social media platform with approximately $170 million, or not $1 million. Hang on. TikTok is a social media platform with approximately 170 million monthly US users that allows users to create and watch short video clips. You guys, if you don't know what TikTok is, you don't know what TikTok is. The platform's content is determined by a recommendation engine originally developed by ByteDance, a China-based company that is TikTok's ultimate parent. While TikTok created a US subsidiary, so they created a separate entity, and partnered with Oracle to handle US operations and data security, so that a separate entity operates and owns the servers on which TikTok is operated in the US, ByteDance retains significant control over the platform's global operations and source code development. That's going to be the substance of a lot of the argument here. In response to national security concerns about Chinese influence over TikTok, both the Trump and Biden administrations attempted various measures to address these risks, including attempted forced divestiture and transaction bans. After lengthy negotiations over TikTok's proposed national security agreement proved unsuccessful, Congress passed a law in 2024 requiring, quote, foreign adversary-controlled applications, end quote, specifically including TikTok, to divest from foreign ownership or face effective shutdown through prohibitions on U.S. companies providing hosting and distribution services. Translation. We are not comfortable, given the length that we are not comfortable, given our discussions and negotiations in the context of our asking you to agree to this set of parameters for your operations under national security. We're not comfortable with the stance you've taken. Therefore, we're going to pass a law that says that this entity, ByteDance, based on its affiliations with the Chinese government, is not allowed to have an ownership interest in this social media platform, which speaks to the American population via its algorithm, its ability to take a bunch of different voices and communicate them to you, the viewer, in a fashion that it believes is going to convey the message that it wants you to read. That's the reading between the lines. The law takes effect January 19, 2025, though companies can avoid the prohibitions by completing a qualified divestiture that eliminates foreign adversary control and operational relationships. The qualified divestiture thing is something I didn't get to in the oral arguments. I actually wanted to hear Elizabeth Prelogger go into that, but I didn't get to it yet. I was still waiting on it. I want to know what it is that the government is asking TikTok US to do and ByteDance to do to allow the operation to continue. Because from what I viewed, it would be relatively simple and could actually involve creating a cutout or licensing and having the license revocable. I don't know. There was a lot that was there that I didn't understand. But I will say the attorney for ByteDance / TikTok US, well, you have one shot in an oral argument. You know what? We're going to get to it. I'm not going to preview too much of it. But maybe you don't shoot for the moon in the first 5 minutes. You make your statement, you take your questions, and you make your arguments, but maybe you don't shoot for the moon. 3 sets of petitioners, ByteDance, TikTok, Based Politics, and 8 individual TikTok creators filed constitutional challenges to the act in May 2024, but the U.S. Court of Appeals and D.C. Circuit concluded the act survived constitutional scrutiny, especially talking about preliminary injunction phase. I'm curious as to claims by the individual creators. I don't know how they get standing, because this is kind of like a law. Like, imagine a zoning restriction, right? If you're just a farmer and the state goes and passes a zoning restriction on the remaining land in the state, right? You own the land and you're farming the land and you're creating the content, or you're creating the farming on the land. And the state goes and creates a zoning restriction that prohibits the use of the remaining land in the state for farming purposes. Do you have a cause of action against the state? Well, I guess if I take that argument to its logical conclusion, if you're a farmer and the state has, and you are farming on land that is owned by, no, you don't have that cause of action. If you're a farmer and you're farming on land that's owned by another person and the state comes in and rezones, do you have a cause of action against the state? No, you wouldn't, because you wouldn't have a proprietary, you wouldn't have an interest. I don't get how the creators get there. I'm curious as to the argument being made there. So I guess we're going to have to see how that goes. So let me pull up the Supreme Court. Why did I say that accent? Not Larry Baldwin. It was terrible. Make sure I've got this gained up, because oddly enough, at the Supreme Court, coverage in the Supreme Court is by audio only, not by video. audio only, not by video. Hang on. Here we go. Audio only is how it begins. And it begins kind of out of nowhere. So C-SPAN covers it. They just have the audio turned on in the court. And the problem is the court is the one that controls the audio. So when the court turns the feed on, the court basically just, you're in the middle of the case being introduced. So right now, Chief Justice is introduced in the case. And here we go.
And the consolidated case. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Under the Act, one of America's most popular speech platforms.
I'm trying to move the closed captions to a place where you can see it. I'm going to put it here.
Will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok speech. So the First Amendment applies. Second, the Act is content-based from beginning to end. It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the Act can't satisfy any standard of scrutiny. The government has no valid interest in preventing foreign propaganda. And its fallback, that it seeks merely to prevent covertness, makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the Act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this Act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the President-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that, in its view...
All right, hang on. Usually Justice Thomas comes in with a softball, but I needed this one. Usually Thomas comes in with a softball, but the reason why I read to you kind of the synopsis of the case is because I honestly think that a lot of the networks and a lot of people that have been covering this have been covering the wrong framework. They haven't been framing the question properly. So the question is this legislation, does it have an impact, material or otherwise, on speech, on a protected interest, speech, association, or otherwise, right? And whose speech is it impacting? If if you're a litigant bringing a lawsuit against to enjoin it, you essentially have to demonstrate that your speech is being impacted. If you're trying to make a First Amendment claim, they're trying to make a First Amendment claim. TikTok is, which means TikTok has to demonstrate that they are the speaker. You can't step in the shoes. Third-party actions when you talk about constitutional claims just don't exist. I don't have the ability as a third party to bring an action on behalf of somebody else saying their constitutional rights were violated. Limited circumstances. When you're the AG, you're the representing the state and all the citizens therein. But I don't have the right to say Joe Schmo down the street, their constitutional rights are violated. Therefore, I seek to enjoin this act from taking place. No, my rights have to be violated. So I needed context to understand why TikTok was making this claim under the First Amendment. So what was their speech? And Justice Thomas comes in and asks a question that I thought was very informative right off the bat. Now, some of you might know that I have a friend who practices and does a whole lot of constitutional analysis, just a whole bunch of it. And I very much enjoy this friend, who is probably one of the most learned constitutional scholars I've been around, honestly. Why did that show up that way? Kurt, you're not supposed to be small. You're supposed to be my size.
How you doing, sir?
How are you?
Doing pretty well.
You watched a Supreme Court case that I did not think was going to be nearly as interesting as it was.
No, I didn't think it was going to be as interesting as it was, and I found some of the arguments by TikTok's lawyers to be kind of on the absurd side, to be quite honest.
Just a bit. And that's,
Yeah.
I didn't realize Elizabeth Prelogar was one arguing this for the government.
Oh, of course she would. Of course she would. I mean, it's a huge case.
I have a law crush on her. Like
I have
more-
a serious
I
law
don't-
crush on her too. She's
I
one
don't
of the,
know.
she is the best in a generation.
Absolutely. She is the next Paul Clement. Oh
Yes.
my God.
Yes. I remember when she
So-
went up against Paul Clement and crushed him.
Really?
Oh yeah.
What was the case?
I couldn't remember off the top of my head, but I remember there's a case where they were versus, and I was like, yeah, no, Elizabeth had it.
Prelogar is damn good. And even when I find myself disagreeing fundamentally with the argument that she's advancing, I am watching and listening to what is happening and going, holy shit, you're good. Like you,
It's just also unfair for anyone to have this much natural talent. She's a beauty queen. She was like in Miss USA like 3 times, like the pageant, and she also is like an outstanding lawyer. So she's not fair. No one should have it all.
Intellect alone puts her in the top 10 of any. I mean, she's just brilliant. She's brilliant. I
No,
love
she's so her
Prelogar.
answers are great. She's always well prepared. She's never caught out, and she can basically redirect any question. She can.
that
She
part.
can. Her judo is better than just about anyone
That
else I've
part.
seen.
And it's the judo. It is the there are very few lawyers and litigants practice in front of the Supreme Court who can tell a justice, I'm sorry, I think you're reviewing that the wrong way. Paul Clement was one.
Yeah, but she doesn't tend to say it flat out. She tends to like redirect it and make it seem foolish, which is even better. Paul Clement would say it flat out. She doesn't tend to do that. She just tends to like redirect it and make it seem like her question was silly the entire time.
I personally think that what I would hate fighting. I'd hate facing off against her because I would hate her argument. I would disagree with it emphatically, and I would see how effective she was being, and I would be like, I can't right now.
I'd love to, because it would bring out the best of me. I mean, I'd get absolutely crushed, but you know, it'd be fun while it's happening.
All right. So at the very outset, we heard some absolutes in the.
Uh-huh.
There's a whole lot of absolutes we're about to hear, and we're gonna
yeah
we're gonna put a cap on some of our comments until we get to a pause point, because Mr. Francisco, I don't think he scored himself any points with half of these arguments.
No. Sonia Sotomayor is basically going to crush his soul, and it gets worse from there.
Well, and Justice Ketanji Brown Jackson comes in with questions, and I was like, how am I agreeing with Justice Jackson?
Yeah.
Because I agree the way you approach this is this is cart in front of the horse. I'm going to speed this up to 1.25 because it doesn't need to be at one speed. We all understand them. They actually articulate themselves very well. There's no stuttering. So, picking up where we left off, Justice Thomas just asked, what speech exactly are we talking about from TikTok, the entity?
I welcome your questions.
Exactly what is TikTok speech here?
TikTok, Your Honor, uses an algorithm that in its view reflects the best mix of content. What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over.
All right, we're about to get the first.
This hypothetical.
Yep.
This hypothetical is so stupid,
so bad.
I don't even know where to start.
It's so bad. Well,
it's let me pick a hypothetical that shows you why I'm right. And the hypothetical proves opposite in every possible way why you're wrong.
Yeah.
It is a stupid hypothetical.
It was.
And then it got worse because he added to it later.
Somehow it did. And I didn't realize what I was listening to. But what I wanted to reframe a lot of this was when you walk into this, TikTok is the one that's bringing the litigation, right? So TikTok is saying, I have a First Amendment interest. And they're saying, all right, what is the speech that you're trying to protect? And TikTok is saying, because the question is TikTok actually out there creating content? No, but TikTok is saying that my algorithm, my choice and selection of these individual content creators itself, my ability to project this information to you is actual active speech. And the way that I kind of use this was if you're talking about an orchestra and you have a composer that's up front, right? The composer is orchestrating a symphony, and you have trumpets, trombones, flutes, bass, you have everybody that's out there, and the orchestra is saying this has to go off in this exact timing in order for this to be a melody that moves your soul and makes you feel something. It's me speaking as a conductor, and I am creating a harmony, and I am basically saying I am conducting this and focusing this out into the world. Each one of those individual actors, they are the ones that are playing the music. I'm not doing anything other than conducting it. But is the individual actor the one that's speaking, or am I the one that's speaking because I'm the one that's synthesizing all of that into one voice? So
yeah, I've no problem with the conductor being a speaker in this metaphor. I'm perfectly happy with that. That's not the point of my contention.
I know. The point is, I'm the conductor, but I'm not the conductor. I'm the conductor, but my hand is up here, and there's someone else holding my arm that is taking my arm and saying, moving it around and telling everyone else to move the stuff around.
Yeah.
And that's where we're about
so
to
you don't
get
so you don't really
weird.
exist.
So I don't really exist. I'm a proxy. I am a shell. I am not really the speaker.
Yeah.
So Justice Thomas asked what you would assume would be a very simple question.
Yeah. And then
then
we get the stupid hypo to show you how stupid it is. Let's roll that beautiful bean footage.
You get an answer, and then you get a double down answer, and you're going, all right, so this is the world that we're in right now.
Jeff Bezos' international empire, including his Chinese business.
All right, so we're talking about Jeff Bezos. That's where we are.
because I think the burden falls directly on TikTok. And I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos's international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down.
Yes, they can.
Yes,
they absolutely can do that. They can 100% do that. What are you saying?
Because the operative word that he used, that was the big mistake that he used, forced.
Yeah, because in this hypothetical, Jeff Bezos is no longer relevant. He might own the Washington Post, except not really, because in your hypothetical, China has somehow commandeered him and or the Washington Post. So he's no longer an actor. He's irrelevant to your equation.
And that's what I mean. The answer is forced.
You've hypothesized him out of existence. Congratulations.
Exactly. You've overtaken his will. You have taken the citizen that had the right of free speech and you de-citizened them.
Yeah, that's great.
You put someone else in their shoes.
So surely if China was able to execute this hijacking maneuver, surely we couldn't act to stop it. Yes, we totally could.
Yes,
what are you talking about?
And actually, we've done that in the past.
Yeah. What are you talking about?
He is arguing.
And then 2 minutes from now, it's going to get worse.
Well, what he is actually arguing is contrary to, I think, existing case law.
Oh, yeah.
Where you can absolutely force divestiture when you believe that an individual is acting through proxy.
Right.
That wouldn't just violate Mr. Bezos's First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law.
No, they're not.
Because they have to go dark
not in your
and close
hypothetical,
up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
That's right.
But the ultimate company that controls it, ByteDance, was found by Congress, and let's quote this, to be subject to Chinese laws that require it.
Why are they keep referring to Congress? And this is giving context. Why are they keep referring to Congress? They are operating under the record. The record is the record that Congress establishes. Congress is the one that basically does all the investigations, that creates the background and says, this is the foundation for our law. When they talk about scrutiny, they say there's certain levels of scrutiny that have to be applied. The scrutiny given is essentially, we have to consider what level of analysis Congress gave. What was the harm Congress found? What was the basis of that harm they found? What was the approach they took to narrowing the regulation around to attack that harm? And did they assess whether it would impact anybody else? So they're focused on the congressional record because that's what established the law. So when you're talking about that, you're saying, yeah, Congress is a bunch of idiots. They are. They're absolutely a bunch of idiots. But this is the record they're operating on.
To assist or cooperate with the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and—
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute.
Yeah. If you believe any of that, I've got a bridge in Brooklyn to tell you. Like, just and Roberts, who generally is less argumentative, jumps right in and is like, wait, do you really believe this?
Dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point.
Here we go.
Warning.
So, here we go.
Warning.
Here, maximum stupid. Here we go.
Warning. Hypo incoming.
Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people.
That is the stupidest thing I've heard. That is stupid on levels I can't even fully comprehend.
So the remedy is that Jeff Bezos has to disclose that the Chinese government has his children held hostage. And that is why he is, but again, Jeff Bezos disclosing the Chinese government holds his children hostage.
Can't interfere with Jeff Bezos's or the Washington Post First Amendment rights, even though in this hypothetical, neither one of them really have First Amendment rights because neither one of them are actually making decisions because of the, kidnapping of the children we just mentioned just now.
You know what's even dumber about this? I didn't even think about this when it was being said. When kidnappers kidnap, they usually say, don't tell anyone, right? Or your kids are going to get it.
Yeah.
Something to that effect.
Yeah.
So this lawyer just said, we could cure this by a disclosure. Asking Jeff Bezos to make a disclosure that his kids are being held by the Chinese government who have said, say this or your kids get it.
I'm reasonably confident that the U.S. government has the power to act with the kidnapped children hypothetical.
This had to have been mooted, right? In theory.
So dumb.
Who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel,
if China has total control, how does Bezos or the Washington Post have First Amendment rights?
They don't.
They're not making decisions.
It's compelled speech. Yes. It's proxy. It's puppet. You don't get to speak through a puppet. That puppet loses their. You don't get to rely behind the shield of the person you're coercing to make the speech.
You've turned Jeff Bezos into a marionette.
Yes.
It doesn't have a voice.
Chinese government is Jim Henson, and Jeff Bezos is, at this point in time, Kermit the Frog. Under this hypothetical.
So dumb.
Now, what I did not expect.
Did this lawyer get this hypo from TikTok? Is that why it's so stupid? Did it pop up in his feed?
I don't know. I don't know. I didn't
What
read.
one brain cell Reddit post did he read?
Well, what I didn't think going into this that this was going to quickly become a holy shit, this is going to be 9-0 until I heard, immediately Justice Sotomayor going, oh no, I want a piece of this. I'm going, oh shit. At this stage here, usually, let me tell you how this usually works. Usually the person that's advocating a position that, well, let me put it this way. You can get a sense of the court's leaning by how harsh the questions are from the certain justices. And usually they follow a certain tack, right? You get 5 or 6 justices asking very hard questions of one litigant and the other 3 pitching softballs. And when the other 3 chime in, they're actually saying, well, isn't it true that this happens? And you're going, well, come on, like ask a question. Don't just make the argument. And it happens vice versa. You see it all the time. The other litigant comes up and then all of a sudden the 3 are attacking and the 5 are coming back and saying, but isn't it this? And you're going, come on, ask a question, do the actual work. Very rarely do you see all 9 just coming in hot and from different angles too. This was
your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take
because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
You know what that sounds like? Association. Immediately, I was like, this is a freedom of association argument. This is, I can associate with who I want to. Why are you not making that argument? That seems like the stronger argument. I can associate with ByteDance's content. I can choose to advocate their content. It's still my speech. I just choose to use it. Why not make that argument? That seems like your better argument. And Justice Sotomayor is like, hey, do you want to try this? But it's a red herring because she's like, no, you don't really want to try this.
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened.
All right, you've lost Sotomayor. At this point, you're just going shit. Because you just had Thomas jump down your throat, Roberts jumped down your throat. Now you got Sotomayor, who gave you a hypothetical you thought was friendly and is now turning it against you and going, oh, you don't like this, do you? And then Lauren, clarification. Do people still not realize the First Amendment does not apply to privately owned social media platforms? Different.
Depends who's
in
acting.
in this sense, it depends on who's speaking. Because
It
of the
also
private
depends-
media.
It also depends on who's acting, right? Because
Exactly.
the First Amendment interest here is because the government is the one that's trying to prevent TikTok or ByteDance from doing something, right? So the government is restricted by the First Amendment. So the idea is that they would be protected by the First Amendment from the government. The reason the argument doesn't work, at least in my opinion, is because ByteDance has no First Amendment protection.
No.
Because they're a Chinese company and they're foreign and have no First Amendment protection. So, yeah. So TikTok USA might, but if they're completely controlled by ByteDance, then, well, it's not really TikTok speaking. So now we're just back to ByteDance speaking, at which point they have no First Amendment interest again.
Yep. Which is kind of resolved in prior case law, but not. This is unique a little bit. At least they try to make a unique argument. I just don't think they get very far. But Sotomayor turns the hypo, and then all of a sudden he's back in the naughty corner.
You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example,
He gave up. That's giving up the whole case. Right there. I do think they would have a compelling interest. Well, you've just set the level of scrutiny that you're allowed to engage.
If you have a compelling interest, then great.
There you go. You're screwed.
Moving on.
Ample, generally applicable laws like the
So you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
So sure.
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well,
we're still having people kidnapped. We're still having coercion.
And be that as it may, you can say to.
Oh, be that as it may.
Did you?
Oh,
by the way, those words exiting Sonia Sotomayor's mouth was not on my bingo card.
Yeah. You know why be that as it may is a problem? Because if you have a First Amendment analysis and you're in strict scrutiny, compelling, then we normally talk about narrowly tailored or least restrictive means. And so Sonia Sotomayor, he's saying, well, you could do this. And Sonia Sotomayor saying, well, that hasn't worked. Means that it means it's not broad enough. Right? Because it's not working.
Yeah.
So if you assume the compelling governmental interest, it means that Congress has been too restrictive in its remedies because it hasn't worked. It needs broader remedies because we need to be able to fix the problem. It's not the narrowest solution.
And
so
when he says,
your proposal fails because it's failed in the real world.
And when he says, be that as it may, it means, yes, we acknowledge this shit is still happening.
Yeah. But we still want the solution that doesn't work because that means it's narrowly tailored. No, it doesn't, because it doesn't work. So it's not narrowly tailored. You need something else.
I know.
Lol.
And we are 11 minutes in, and this argument has fallen apart to this extent.
To Americans, you cannot collaborate with our enemies at all. And if you do that, you're going to be severely punished for doing
All
it.
right, we can go on to the effectiveness of the remedy. But the point is, I believe that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context.
All right. So just so we're counting, we've got Thomas, Roberts, Sotomayor, and now Kavanaugh. So you got 4 who are already signaling by their questions they ain't buying it. Only need 1 more. But are we going to go for we're going to go for all of it, right? We're going to go for
we're definitely doing the Pokemon catch 'em all style over here. I'm telling you.
We're doing the full house, right?
Context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
keep going.
You can't really take those cases and extend them to an area where there is no scarcity, like the World Wide Web, because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights. And I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to.
And he's lost his argument. That's lost.
How can a foreign government have First Amendment rights in the United States? Whether or not the foreign government exists at all is a matter of discretion up to the United States government. We can just say we just say your country doesn't exist, and then you don't. Poof.
The thing is, Alito was like, "Come on, fight with me here a little bit." He did. Alito was like, "Come on, fight with me here a little bit." Right? Let's say that the government outright owned it. They wouldn't have an interest, right? Alito's like, come on, make the argument. You have to, because if you concede this point, all I have to do is demonstrate that this is a proxy speech, right? But he concedes it.
See where you draw the line. So it's true. The court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that. All right. What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different.
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
because there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States. Why would it all change if it was simply hidden under some kind of control?
Now, Alita ran over him in this question. I have a question for you on this one. Compare the entities like Politico or Al Jazeera who have an operation in the U.S. and they're allowed to operate in the U.S. and they have foreign ownership interests. Do they have a First Amendment right?
No.
The entity, at least Politico, is at least, I believe, a shared board. I believe some of the board is here.
I'll state this: like, for my money, the United States government can pass a law relating to any country at once. And if the United States government wanted to say that, for example, Germany was a threat to the national security of the United States, which, depending on what decade of America we're talking about, could be a law that the United States could pass. I think there might be some interest in potentially saying Germany is a threat to the national security.
Right.
So yeah, I mean, I think the United States could prevent foreign ownership by Germany or any Al Jazeera or anyone else if they were so inclined.
So essentially, bad examples because they have it in this case, it's because they didn't find a need to in this case, right? You're giving a bad example because they didn't do the same analysis that they did in this case with TikTok as they did in Politico, which is engaging in speech that at least is from an actor standpoint, as far as ownership, is not owned by an actor that the U.S. views as inherently adversarial.
Yeah. Why don't we bring Japanese ownership into it too? We can talk about that. That'd be good.
That's true. And AT&T, I mean, Thomas gets into it later. AT&T broke up because of ownership interests.
A corporate structure.
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like.
No. That's wrong. That's wrong. That is not the same thing. They could order AMC to be sold so that it wouldn't be owned by China. But that is not the same thing as saying they have to censor the movies. Congress has not told TikTok they have to censor one thing. They simply say you can't be owned by China. So if Congress passed the AMC being owned by China sucks act, then they can force AMC's sale. Congratulations.
And he goes down this line of speech argument, and a friend of mine tried to make this argument to me, and it caught me off guard. And I was like, wait, this is different. Why are you talking about this? This makes no sense based on the argument that's in front of me. I'm not talking about compelled speech. I'm talking about ownership. And it felt like conflating the issues.
Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right, let's
an
say that's not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Side note, petition for the justices to update their fucking profile pictures. This is all of them are like 10. These photos are when they first take the bench. Like, these are old AF. Just saying.
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment. And if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok US has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, And there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
What is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon.
Let me rephrase what this lawyer did not say. TikTok, as a U.S. company, has a choice of whether to use or not use the algorithm. It does not have any influence over what the algorithm says, what it does, what it directs, how it's manipulated, how it's used. It has no control over that. It has the ability to decide yes algorithm, no algorithm. That gives a little bit different context, right? Like just a bit to what Justice Gorsuch is asking. I just
abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay, and then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact.
Hold the fuck up.
So the
Wait,
so the algorithm
wait,
is owned by China.
Wait,
Oh,
yeah.
okay.
Wait, hang on. Did he just make that concession like openly in court and say that there are certain parts of the source code that are owned directly by the Chinese government? I'm pretty sure he just did.
Yep.
So
also by certain parts of the source code, I'm pretty sure he means the source code.
The source code.
Those are parts.
That, yeah. All right. This. How many ways can you lose in one oral argument? Because I'm up to like 12.
That this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it. Okay, I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions. Sure. I just want to understand what's before us. Would it be feasible in any
I'm going to let you laugh on this one because the answer is worth it.
time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code. And as we understand their interpretation of qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because as we understand how they're interpreting it, a qualified divestiture would divorce the US platform from the global content. So for example, there are videos created in the United States, there are videos created in Ireland. In order to get global content, we need access to the Irish videos, they need access to the US videos. We understand that couldn't happen.
Okay, so you think it's probably...
Wait a minute. Okay, so
lies.
Part 2 is just straight up bullshit. You're saying you can't get the international videos because no. As to part 1, Kurt, 270 days. A global team of engineers.
I think that if TikTok wanted to, they could do this in very quick order.
Right.
I think that if they wanted to separate this off, they could do it in very quick order. You know, how hard would it be to separate out the algorithm? Not that hard. It wouldn't be possible in any time frame. 48 hours. You know what I'm saying?
I mean, TikTok is saying they can go dark in a 24-hour period. They can go dark. They can shut everything down in a 24-hour period.
Mm-hmm.
That means arguably
they're just playing chicken. They're just playing chicken, seeing who's going to blink.
They are. And that's where I got more and more
I
frustrated.
promise you, if the U.S. doesn't blink, TikTok will be back within 6 months.
I got more and more mad the more I heard this argument being made, because I kept on viewing the position by ByteDance and TikTok being more and more ludicrous. I was going, wait, you're saying that this is so egregious. This law is so egregious. It is so impactful. It is so significant. It does all these things. What is it asking you to do? Well, it'd be really hard to section off a bunch of engineers and operate a separate algorithm.
I wouldn't be surprised if there's a switch built into the code that you can just flip the switch.
Oh, I guarantee if the 19th comes around and they're like, divest or what, they're going to be like, hey, here's our corporate filings that we filed last month, and here's all of this, and here's this, and we're going to be up and running the next day. This argument gets worse. I don't know how, but it keeps getting worse.
Not feasible.
Oh no, I thought
Well,
it peaked with the Bezos hypothetical.
Hang on, sorry, go.
I thought it peaked with the Bezos hypothetical. That was that's where it went off the cliff for me.
That was solid. I like when Kari Barrett comes in and then Jackson jumps on. This is everyone has an invite to this party. Everyone does.
Back question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows first what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency.
Removed or restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record. It's very difficult for me to respond to things where I don't know what the accusation is.
I have other questions about the secret evidence in this case, but we'll get to that later.
Mr. Francisco, can I ask you a question about the relevant speech here? So it strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination, because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. I would say the algorithm is a lot of things. The algorithm has built within it. It's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation.
Yeah. Hi, I'm Amy Coney Barrett. I'm Amy Coney Barrett. This is Trap. I lay Trap out. It is Trap. It looks very pretty. You want to walk on Trap. Do you walk on Trap? Me decide. I don't know. Here is Trap. He's just
elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says, or say, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm. That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was the covertness untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level of the application. Let's say that I agree with you, the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. There's disproportionate burden. Let's say that I agree with you about that. No one is preventing you. You're seeking access to a particular source code, engineering, the recommendation feature. It's a technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. I mean, the government is fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Let me explain why this is a bit of a problem, because this is a bit of a fucking problem. When we talk about speech and people are wondering why the speech matters, why is it important? Because the ability to give videos in a progressive format or to, I mean, talk about suggestive retraining or reprogramming, right? So you don't jump in and automatically give them something they would view as being oppositional or defensive. I'm a viewer. You're going to send me something I disagree with immediately, and I am automatically going to turn that off. I'm going to ignore it, right? I'm going to go ahead and block that. But if you don't go straight into that type of content, but you subtly gear me or aim me towards that via other algorithmic choices of selections, right? So you start to tailor the content that I'm seeing a little bit more in this direction, a little bit more in this direction. You have engaged in reprogramming. Like you're reprogramming. Like, so the algorithm has the ability to give content to you in a fashion and in a delivery method that allows for you to essentially reprogram other people. That's the concern. If a foreign government that's adversarial to the US government says that, well, doesn't just say, but can reprogram all the individuals in the US based on this algorithm, and the algorithm is the speech, then that's your problem. That's what's being said by the Congress in this act. So when you're acknowledging that the algorithm is the speech, but you're not addressing some of the concerns, I don't think you're going to win.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech. Then you have to look at whether the law itself is somehow content-based, not just what their motivations are, but whether the law is content-based. And here, the trigger for this law, the one thing that gets it going is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review. Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is—
Could I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. I had understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. And if I was unclear on that, Your Honor, I apologize. That's
okay, because I think what Justice Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company. And you started off with Justice Alito saying, you know, well, we would be making a different argument. And of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. And I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture. That's not just ByteDance's choice. That is a condition.
Well, I
that's
realize that
imposed
it definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects. But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else.
and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business, product, and travel reviews, it then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
The idea of just like, you know, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure.
Wait, was that you breathing or was that the lawyer breathing?
It was the lawyer.
Really?
Yeah.
That's a hot bike moment because Kagan is jumping back in and he
reviews. It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
The idea of just like.
Yeah, that's them.
That's
That wasn't
not
me.
good.
That wasn't me.
That's not good. That's not good at all. That's bad. That's a bad sign. That's a bad sign. That means I'm having a very bad day. That's a please stop asking questions. Oh no. All right, let's fast forward a bit because Roberts comes back in. I want to get to this dialogue where I was like, I am not agreeing, but I am.
Every word he says, I disagree with and or think it's lies.
He is. So TikTok's claim is shot to hell, right? So we can agree to that, right? Their entity claim, the corporate claim, gone. Bye.
Yeah.
At least the First Amendment speech claim. But then I'm going the association claim. Maybe a little hope, but he shoots that one down too.
To draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict
scrutiny. So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree. And I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok, TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated. TikTok Incorporated.
Justice Thomas, Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens? And they said, this is the worst offender, and we're going to require divestment.
The data argument. I forgot about this part. So the data gathering argument. Different part of the argument was that essentially the gathering of the data itself and being held by this foreign actor would essentially, this is the weakest argument for the government because the TikTok offered a lot of server security.
Yeah, Project Texas. They gave the data to Oracle, which happens to be based in Austin.
They completely surrendered the data and they said, we're not going to use it. We surrender it. We can't employ it elsewhere. We can't sell it. Like, that was their, like, please God, don't ban us. So this is the weaker argument for the government.
That assumes that we trust you, which incidentally, the DC Court of Appeals had a lot of problems with, like the idea of the lesser remedies. Because if you read the DC Court of Appeals opinion, they said, well, here's a bunch of things that like TikTok proposed as lesser remedies, including this thing as Project Texas. And the DC Court of Appeals said, well, none of those really work, including Project Texas, because it requires the government to trust you that you're going to do this. You're going to do it indefinitely. You're not going to backdoor this thing. They're going to require, it's going to require them to monitor it on an
And what's our
ongoing
remedy
basis
if
to
you
make sure you're
violate it?
actually doing it and not trying to get around it the first convenient thing. So it's like it basically fundamentally requires the U.S. government to trust you, which obviously they fundamentally don't because we're here in the first place. So Project Texas doesn't work for us because we don't believe you.
Yeah. Where was it that? Here we go again. Oh,
We promise to
Right.
never
But I
ever
don't
sell
think
your
that you're-
data, said the con man.
Actually, yeah, that's kind of the argument that would be a very good analogy to what was being offered. I will let you keep your data in this location that I know about and know where it is and know how to access, but I promise I'm not going to take it.
Your question, that the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, Your Honor, I think they'd be very similar because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I can
All
unpack
right.
that a little.
No, I'm not going to, because we're going to run out of time. Because
Oh my God, you just got shut down on the clock by Sonia Sotomayor.
Yeah, it's like, let me tell you why we went under intermediate scrutiny. It's like, nah, that's okay, I'm good.
And you know what's funny is Justice Sotomayor, by the way, pro tip, Justice Sotomayor isn't very much like, I'm going to hide my cards when she says, suppose I agree with you that intermediate scrutiny applies. She agrees with you that intermediate scrutiny, she doesn't play that game. Others do, but she doesn't. When she says, suppose I agree with you, intermediate scrutiny applies. And then you start to give her a bullshit answer. She goes, all right, you failed. It just moves on. Oh,
we're going to need to figure
bad.
out what intermediate scrutiny means, but I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our cases have said we have to use a reasonable means.
And if I could respond.
Bonnie Joe Savlin, I've seen this comment a couple times. No, and how?
Yeah. Russia, no, Twitter's fully owned by Elon. It's owned by a guy.
A person.
Yeah, so it doesn't work. Russia, it doesn't work.
It's not an entity.
Yeah.
And unless you can demonstrate to me that this individual is a proxy for that. And you know what? If here's the thing. Let me take your logic and let me employ it one step further. Let's say Congress does a full investigation and Congress somehow finds that Russia has a hand up the ass of one of these owners and is employing Elon Musk as a proxy. Let's say hypothetically we're in this world. Can Congress regulate X? Yes.
Yeah, then Congress could come in and do exactly the same thing. Yeah, 100%.
Absolutely. Yeah, they can come in. They can say no. X has to divest of Elon Musk. Like they can do that. That's the difference. Very different argument.
But you're going to need a little bit more evidence than testimony from Moose and Squirrel.
You need to develop a record, which is what they keep going back to. They keep going back to the record here. That's why I said the congressional record is what they rely on. That's what they're doing. The law was passed based on a record. If you want to make this argument, great. Get the congressional record, make the law, pass the law, then we can subject to this test.
Under that point specifically, I completely agree it's not a least restrictive means alternative, Your Honor, but you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your finger on.
No. Why? Why? I don't think you've gotten me there where I have to consider alternatives yet. I don't think we're at intermediate scrutiny. Oh, wait. So she gave him that.
I know you want to keep going on, but I can't let you because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am not.
If from the record, it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that, that might be enough.
Now
But
I take
here
that.
on the
Now let me
key-
go to the next question and the last.
If I could,
The
Your Honor,
DC
just
Court of
one
Appeals
thing.
thought it was pretty clear.
If on the key, less restrictive
Yeah.
alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even consider.
The Court of Appeals flat disagrees with you.
don't-
The
they
Court of
don't-
Appeals flat disagrees with you. The Court of Appeals says explicitly in their opinion, yes, this idea was floated. Yes, it was considered by the U.S. government. It was deemed insufficient by them. They didn't think it was good enough. We understand why they didn't think it was good enough, because it would require monitoring and trust. They did consider it. It's in the record.
I thought this was going to be a closer argument, and it is not. This is a shellacking like I have not seen in the Supreme Court in a long time. You know what? California EPA, that argument this year, I thought was a pretty good shellacking by everybody. No.
Well, at least on the plus side, he won't have to wait very long for his opinion from the U.S. Supreme Court. They should be handing it down probably within about a week. So good news.
I mean, we might get it tonight. Who knows? I'm being facetious there, but yes.
And that's why it would
because
fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go past
That's incorrect, actually.
that. No, because the NSA doesn't.
She goes, no. I actually read the record. She goes, no, I read it. We have this finding. So
I'm not talking about the NSA.
Or even anything else. But putting that aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm. Correct?
It doesn't permit them to speak to the American public through the algorithm,
right,
and promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with
ask
was secret,
Xi about that. How do you disentangle the two things?
Thank you, Your Honor.
In the government is it content based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is in fact content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable. They will mix around their videos in a way that is too pro-Chinese or too anti.
That's stupid. The government is saying that they're worried about TikTok because TikTok is the sock puppet. Of course, they're identifying the sock puppet. That's the person speaking.
Anti-American,
Okay,
and that is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But that's what Justice Gorsuch said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source.
So, well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing.
Sure.
How long would it take? Tomorrow?
Yeah.
Day after?
Yeah.
Of content. That was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations. And the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture. So isn't this really
And at this point in time, I realized in the day that either I A, did not have enough caffeine, B, hadn't slept the night before, C, hadn't eaten enough, because at this point, my brain was 100% in line with what Justice Brown Jackson was saying.
That's funny.
And I never agree with Justice Ketanji Brown Jackson. Like, it just in how the questions are posed or the arguments made, we just philosophically view the law differently. Fundamentally, we just do. But she asked this question, I was like, holy shit. Here's your 9-0. Right there.
Justice Jackson secretly based.
Justice Jackson was like, let me tell you that this is about you repeating someone else's speech. Let me ask you to fall right into that trap. And you don't want to, because all of our case law says that we can absolutely restrict your ass in doing that. I was going, holy crap.
your right of association case under the First Amendment?
I think it's both, Your Honor. I do think that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises.
But it's ByteDance's algorithm.
I also think more directly.
That's the problem.
It says that TikTok
It's not TikTok. It's
ByteDance doesn't
ByteDance's.
exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post divestiture or whatever, pre-divestiture, come up with its own algorithm, right? Then when the divestiture happened, it could still operate. It doesn't say TikTok, you
I think
can't
that's
speak.
theoretically correct, Your Honor, but I think that also underscores the content-based nature of the restriction.
No, but the fact, excuse me.
No, at this point in time, I'm like, for the first time in my head, I am in my truck listening to this argument and bobbing my head along with Justice Ketanji Brown Jackson. And I'm like, yeah, I'm with you on this point. Go, get him. This is where my brain was. And then I paused at the stop sign and I was like, what just happened? Where? I'm uncomfortable right now. What just happened? But I was happy for it because it was so common sense.
The fact that that's true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
And ultimately upheld the law, so fine.
But sure, and if we go down the
wait, so hang on. Kurt, help me explain this one to everyone in the chat.
No, it's great because, there's a whole bunch of examples, in the past where they've tried to restrict people. And he's like, yeah, well, they apply strict scrutiny. And Justice Jackson's like, yes, but they all pass strict scrutiny.
They all upheld the law. So they applied a higher version of scrutiny.
So
all of them
worked out, was fine. Was all good.
And the laws were still good. So wait, here's my foot. Here's a gun. Here's me aiming at my foot.
I'm not
And
sure I've ever
hoping-
seen someone fail strict scrutiny this cataclysmically. There was a paper I once read that said strict scrutiny is strict in theory but fatal in practice, because you can't do it. Strict scrutiny is impossible. You can't meet strict scrutiny. It's impossible. It can't be done. And this guy is failing at that in multiple different ways all at the same time. It's somehow glorious.
Wait. Explain it better. Because here, strict when a law is subjected to strict scrutiny,
yeah,
it is subjected to the highest standard of scrutiny,
Yeah.
which means that for a law to survive strict scrutiny, they have to have compelling governmental interest.
Yeah, and then the part where
cannot
usually
just be
the part where they usually flub is the least restrictive means. That's the part where they usually fail.
it's the least restricted. They have to exclude.
It has to be as narrow as
all
possible. It can't
other
cover anything
means.
more than it has to.
Exactly.
And that's
You
really
have to-
really hard.
You have to
That's
go through
really
analysis and say we have considered every alternative and we have no other method of achieving the end goal of protecting this compelling interest than to enact this law. It is a death sentence to any law.
Right. So normally it says strict in theory because like the idea is it's hard, strict in theory, but fatal in practice. In practice, it's impossible. So it goes from really hard to impossible. It can't be done. Now it's an overstatement, but not by much. And here he's like, they have it. They have strict scrutiny. How many different ways at this point? 4 or 5 different ways at this point. And now we're talking about other cases where they found strict scrutiny. So we have precedental comparison where we've met strict scrutiny. It's like,
And
how
Jackson said
wrong can it go for
in-
you? How many different ways can it go bad?
Every one of those cases where the courts applied strict scrutiny, which is the highest standard, which means the government loses 10 out of 10. In every case where the court applied strict scrutiny, which means the government should fucking lose.
Yeah.
Every one of those was upheld.
Yeah.
And he says, yes, you're right. But I'm like, no. You don't get to do the yes, you're right. And then like throw in a subtle, but now.
It's so much worse the second time.
And
it's so much worse the second time.
And this is the thing. Like I said, usually Justice Jackson is the one that I'm sitting here fighting against logically. I'm sitting here going, go. Like you've got him right here on the ropes, and he is just, these are knockout punch after knockout punch after knockout punch. And he's gotten them from Alito, Thomas, Jackson, Sotomayor. Kagan got him with one. Gorsuch got him with the factual one. Hell, Kavanaugh got a shot in early. Coney Barrett got in one. Who hasn't taken a shot at this guy yet?
Strict scrutiny road here, I don't see that this law can possibly be satisfied under the interest that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring. I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security. And two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating, we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content. And I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are.
And you have just lost your argument like tenfold. Like you are conflating and not trying to. So this was a question I saw brought up repeatedly, and it's not just, and H Scorpio, I'm not bringing this up for a reason, but the question was, people were asking if this applies to TikTok, why not this? Why not this? Why not this? And my answer to every one of those is it could. It could. If there was a congressional record that had this factual basis, that was a foreign entity owned this company or owned a part of this company or owned a significant element that was the purpose behind this company operating, the algorithm, right?
Yeah.
All of these things could be regulated. That's the question here is, can you regulate this?
With respect to the chat, I think on this occasion, I have to say that those questions are basically whataboutism. Because could Congress pass a law that deals with Chinese ownership of other companies or foreign ownership of other companies,
yes,
or data privacy more generally, or the sale of data, and should they do those things? Yeah, maybe all those things. But the question for the moment is, can Congress do this thing?
Yes.
It's like, we see this problem, we've decided to fix this problem. It's like, but there are problems everywhere. Yeah, but Congress decided to fix this problem.
Yeah.
So can they do that is the question. Should they do more things? Can they go further? Yeah, probably.
Well, and here's the problem with that.
Maybe next year.
Let's say, well, and that's the next year, maybe next year. Here's the problem with the logic. The logic is, can you do it to all these other things? And the answer, the appropriate answer is not without the congressional record that they established. You can't just jump in there and say regulation because.
The fact Congress did it means a lot, because it's like, for me, I think it's even simpler than the court is making it, because for me, it's just basically an import issue. Every nation has a fundamental right to control what comes in its borders. We don't want to allow the importation of TikTok or the algorithm, if you prefer. We don't want to allow the importation of the algorithm.
Yeah.
And so it's just basically a border control issue for that issue. And you have a law of Congress that says we're going to ban it. Okay, so it's just contraband. Like anything else, customs seizes at the border. So what?
The AT&T breakup that Justice Thomas brought up earlier, but not in this sort of colloquy, but Justice Thomas brought up earlier, was like, you mean like the AT&T breakup? And he was like, because AT&T at that point in time had a foreign ownership interest, and we said, no, you cannot do that. And AT&T was like, well, shit, this is going to be very costly. And the government was like, no, we have the factual record. Here's the law. And AT&T was like, okay, we're going to break up. They have the ability to do these things, whether you agree with it or not. That's why you vote your congressman in office.
It turned out okay.
It did.
The world moved on.
It did. All right. So Jackson goes, Jeffrey Fisher, he reps the content creators, and I don't think they have a dog in this fight. Did you find anything compelling in his argument?
Nope.
Here's a question for you, Kurt. I got maybe 10 minutes into his argument. Did they contest standing in any regard?
I don't recall standing being brought up.
How do they have standing? The content creators.
I guess it's like inhibiting their right to speak because it's destroying the platform. It's destroying their right to speak on the platform because it's community created speech.
Oh,
and there is case law that sort of speaks to this principle more broadly, like the idea that it's not okay to ban all newspapers because you allow radio stations to continue to exist. It's not okay to ban all pamphlets because magazines still exist, right? That kind of thing. It's like, just because there are alternative channels does not mean it's okay to completely destroy a channel of speech. So there is some case law on that point.
We're going to listen to a few minutes of this guy because I want to hear his point, and then I kind of want to get, because I haven't heard Pre-Logger, and I very much want to hear Pre-Logger on this. Because I feel like
I always want to hear Pre-Logger.
I'm making this inartfully, and this is 100% a fucking legal crush, because I could listen to Paul Clement all day long.
Pre-Logger's so good.
Paul Clement could sing me to sleep. Just argue me to sleep, Mr. Clement. General Pre-Logger is like second best to me.
If the Democrats don't name her to the bench someday, they're missing out.
They are absolutely missing out. I think she'd be good on the Supreme Court, to be honest.
She's incredibly smart, well-versed, knowledgeable. She's wicked smart. She does her homework.
Like, I was skeptical of Justice Kagan, and Kagan turned out for me to be pretty damn good on that side. Yeah, I disagree with a lot of her opinions, but I think she's logical for the most part. Pre-Logger, I'll disagree with for a bunch, but damn it if she doesn't argue the hell out of it. I'm still a Paul Clement guy through and through, though. My loyalty is to you, Paul.
Subject to strict scrutiny because of the First Amendment implications. And the Act fails that test, and indeed any level of scrutiny under this court's case law, because the Act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with its implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we've faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly are the creators?
No, bad pause. No.
Being impeded.
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other
But it
Americans.
doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with
using that
particular
argument,
publisher.
you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, look, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership. It's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online.
What's the perspective?
Also, when it's foreign, why do we care?
Yeah, that's what I mean. How are you saying that this is?
Incidentally, by the way, like this is also true for coming into the United States. So the United States has, for example, prohibited people from coming into the United States who want to come here for the purpose of like attending certain political rallies. Even though, like, if they were here, they could attend the political rallies. But because they want to come into the United States for that purpose, the United States prohibits them from coming in, which we can do because they don't have First Amendment rights until they're here. So, you know, there's that.
I just, I feel for the creators. Like, I get it. I understand the anger and the frustration that this is being regulated out from under you. I 100% get it. Like, let's say that Congress says YouTube presents a national security threat, and they do. Let's say that Congress creates the record they did with TikTok, and the algorithm that YouTube has is owned by a foreign company that is pushing out, and they do the same factual finding, and all of a sudden YouTube has to divest or the platform's gone. Does that suck? Oh yeah. Do I have a cause of action against the United States? I don't think so. So I just didn't see this being.
The United States has the right to close itself off from the rest of the world if it wants to.
It sucks.
I mean, you know,
like do you want to? That's why you vote. This is why you vote, people. This is why you vote.
No, but then it
Congress
just becomes an issue of policy. That's exactly the point. It's just an issue of policy at that point.
It's
How much do we
policy.
want to interact with the rest of the world? How much do we want to let them interact with us? What do we
Well,
want to
these
allow them to
people
bring into
in-
our country? And so forth and so on.
Exactly. Which means that different representatives can make different choices that do different things because the will of the people has changed.
Yeah.
Online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform
These were stupid arguments. This
is shot through with the ownership from
That's
top to bottom.
that's where we do our best. I'm proud to be an American. At least I know I'm free.
These
You
are
know?
stupid arguments because this is the whataboutism that Kurt was talking about earlier. This, you cannot, if Congress established the record that they had with this particular case, if they established that record with Fox, with Elon Musk, with X, with all these, if they established that record, could they regulate it and say, get out of here? Yes. That's the fucking point. You don't get to conflate the issues. You don't get to say, what about this case? Well, that's not this case. That's that case. And they didn't do that. So stop trying to. I don't know. This guy's getting on my nerves real quick.
Prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States. I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right. So I'm glad you're bringing that up.
Yes.
So when it comes to national security, you are right that Congress can prohibit.
No, don't do that. No, I need to hear this argument. I need to hear this argument. Please, for my sanity, I need this argument.
Can Congress prevent the spinny wheel? That'd be nice. Let's pass the no spinny wheel legislation.
We need a whole legislative record. Like a whole legislative record. We need 2 years
Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine US leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, I think the place I would point you most directly would be the opinion.
It's not.
Your fundamental, and I don't like
when
this
it's foreign. It's an
lawyers,
extremely legitimate governmental interest. It's all the legitimate governmental interest.
When lawyers do this big pontificating statement, when they say my fundamental proposition or my submission, my submission at its core is they absolutely do. I'm like, well, you're about to not like the fact that you gave that absolute statement in argument because that doesn't make sense. When they're a foreign entity, they don't. They just don't.
Sometimes the United States kicks out your entire embassy because we don't like you anymore.
And they're allowed to.
What rights do you have then? Not much.
It's called sovereignty. And certain countries have sovereignty. You know what China does in retaliation? They kick out your embassy. It's called sovereignty. And it's called policy. and it's called making decisions policy oriented that result in laws that get enacted by your legislative branch because policy dictates that this is the direction your country wants to go. Like you can, what can Congress do and not do?
Congress's
A
power
lot.
at the border is absolute.
They can do a lot.
Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't
That pissed me off. That pissed me off. That pissed me off personally. Brandeis's opinion in Whitney v. California is no lie my favorite Supreme Court opinion of all time. It is my favorite opinion of all time. And for him to mention it, I'm like, take that name out of your goddamn mouth. Sorry, but pissed me off.
It's one of the most cited concurrent opinions ever, right?
It basically in 3 paragraphs sets out the foundation of all First Amendment law. Yeah, that's what it sets out all of First Amendment law in basically 3 paragraphs. It's like, yep, that's it. Yep, kind of important.
Despite arguments to the contrary, which had seemed to me persuasive, it is settled that due process clause of the 14th Amendment applies to matters of substantive law as well as matters of procedure. Thus, all fundamental rights comprised within the term liberty are protected by the federal Constitution from invasion by the states. The right to free speech, the right to teach, the right to assembly are, of course, fundamental rights. Where's he go on? Where's the line? What am I looking for? It's the one.
Courageous, self-reliant men is the one. Oh. It's like that paragraph to courageous, self-reliant men. It's like who did not fear that entire paragraph is like the foundation of First Amendment law.
Those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. To courageous, self-reliant men with confidence, and by men he meant mankind, with confidence in the power of free and fearless reasoning applied through the processes of popular government, no danger flowing from speech can be deemed clear and present unless the incidence of the evil apprehended is so imminent that it may befall before there's opportunity for full discussion. Thank you, God. This is phenomenal.
If there be time through the processes of...
if there be time to expose through the discussion the falsehood and fallacies.
Yep.
To avert the evil by the processes of education.
The remedy to be applied is more speech, not less.
Enforced silence.
Yeah. That's basically all First Amendment law explained.
Only an emergency can justify repression. Such must be the rule of authority is to be reconciled with freedom.
Yep. I'm not crying, you're crying.
It's amazing because if you give the government the foothold, they're going to walk all over your speech. They're going to control it if they can. If they can, they will. They absolutely will. And it's words like this that are meant to protect you from and protect your rights. Your rights.
Yeah.
Now, the argument being offered to you by Mr. Fisher is conflated. So you just heard those words about more speech, not less.
What was that decision? 1939?
It was 27.
Oh, it was earlier than 27. Yeah. Yeah, I mean, it's ironic because in Whitney versus California, they convicted Whitney for being a member of the Communist Party, and the Supreme Court upheld the conviction. So they upheld the conviction for being a member of the Communist Party. But then Brandeis wrote this incredible concurring decision, which, even though he didn't realize it, basically became the foundation for all First Amendment law about, 12 years later, when they were like, oh yeah, the First Amendment, maybe that's a good thing. Maybe it's okay. It's okay to be a member of the Communist Party.
People made this comment about Scalia, and people ripped on Scalia for his dissents. Do you know how many of Scalia's dissents become controlling case law?
Oh yeah, I mean his great dissent, Morrison v. Olson, 8-1, and it's basically the law. Yeah,
a ton.
Yeah,
because of how impactful the writing is. and you get a court that's torn on how to decide a case in the future, and they look back at that impactful writing, they're like, well, holy shit, I can hitch my horse to that wagon. And they do. This bothered me because this is not those words. This is quite different. We'll allow them to say it again.
Allowed. So I don't really understand what you mean.
Right. So I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally.
Oh, I see how he's getting it right at the outset. The Communist Party. Oh, no. No.
Different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine US leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security and the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism? Is it where our battleships are located?
Justice Kavanaugh presented a number of potential risks. Right, with foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now, there's a secondary argument the government.
Why? If the content being advocated, and the thing is, you sugarcoated it. If the content being advocated is anti-democratic, anti-establishment of the United States, anti-democratic meaning advocating for a position that would, for example, let's say the algorithm was pushing for the overthrow of a certain democratic process, such as elections. You're saying that the U.S. government doesn't have a legitimate interest in that? You're out of your fucking mind. No way. No way. I don't care if it's even subtle, but if the actual actor is out there saying elections, you've seen that apply. I mean, apply it in reverse. You've seen it employed in the U.S. on speech against U.S. citizens in their First Amendment rights. You've seen the government come out and say that shit.
Yeah.
They absolutely have a right to do that. And they have flexed that muscle time and time again. All right, I got to get to pre-logger because I got to hear how she defends this. And I can't with Mr. Fisher right now. And the reason why I'm not shorting Mr. Fisher here. I just know that their position's already been annihilated. I've seen all 9 justices come out against them. I don't think he's going to give me anything else that's going to help. I want to see how the justices attack General Prelogger and how she defends it to see if there's any, I don't know, holes in her argument. I doubt it, but I'm very curious.
General Prelogger.
Mr. Chief Justice, and may it please the court, the Chinese government's control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks.
Right off the bat, let me tell you why she's different than most litigants. Pace, tone, enunciation, cadence, all of the above. You don't miss a single word she is saying. And she is fucking whippersnapper smart.
To undermine U.S. interests by amassing vast quantities of sensitive data about Americans and by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data. And as Justice Sotomayor noted, it's not just about the 170 million American users, but also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans, where we live and work, who our friends and coworkers are, what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment, recruitment, and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The Act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats. Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control.
Boom. How is she this good?
Boom, boom, boom.
How is she this good?
Side note, you get 2 minutes. You get 2 minutes uninterrupted, right? So the first 2 minutes are rehearsed by every lawyer to the nth degree. You have recited that thing where you are saying it in your sleep, you are dreaming it, you are enunciating it. You don't change it, you don't manipulate it to the point where, like, if you are cut off in the middle of it, you just keep talking. That first 2 minutes is your only chance. So no lawyer ever goes off script. She went off script twice. She just addressed two arguments made by the other attorney in her opening 2 minutes. God, I hate her.
She can't keep getting away with it.
I hate her. I hate her. I hate Paul Clement. I hate them both. I hate the talent they have. You know how fucking scary that is? Like, do you know how scary that is to be in front of judges like that and just get ripped to pieces and to stand up there and say, oh my God, I hate them.
How she do it with such flow, though? That's the thing. Like, the incorporation isn't, the corporation isn't actually the hard part. The hard part is the flow. How she do it with such flow? It's
same
like
way Paul Clement
it's perfect.
It's the same way. It's the same way. There's not a hitch in the armor. It is the same cadence. And wait, because when the justices start cutting her off, she fires back with the same cadence. It's amazing. She doesn't get snippy.
No, she never gets snippy. She never gets snippy. She never gets mad. She never gets condescending.
I disagree with 90% of her arguments, and I'm giving her all of these points. Oh, this is a good question. So Aislinn Baltus brought this question up. Just curious if how a dissenting opinion becomes controlling case law if it's the dissent of a case, because the case comes up again. So the dissenting opinion says, y'all are making the bad decision, and this is why. And then a case 5 years from them comes up on similar facts, but it feels very wrong applying the same law. And the court that's taking up this new case goes and they look back at that dissent and they said, holy shit, what you just said was going to happen happened. And we're going to go ahead and take your logic and apply it to this case. And now you're the controlling opinion. So that dissent is given credit for changing the law because that dissent foresaw where the law would go. Hope that answers that question.
The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security. I welcome the court's questions.
Is there any difference between content manipulation by a non-U.S. company as opposed to a U.S. company? I didn't hear Mr. Fisher make a distinction between the two.
Yes, and I think the important thing to recognize is that the act here is targeting covert content manipulation by a foreign adversary nation. Now, I understand my friends to
What
say—
difference does that make?
The difference is that there is no protected First Amendment right for a foreign adversary to exploit its control
No, I
over a
mean
speech
the
platform.
difference between covert and non-covert.
So I think that Congress's concern with the covert operation was that a foreign adversary could effectively weaponize this platform behind the scenes in order to achieve any number of geopolitical goals. Here are some of the examples that come to mind. One of the pages out of the playbook here is for a foreign adversary to simply try to get Americans arguing with one another to create chaos and distraction in order to weaken the United States as a general matter and distract from any activities that the foreign adversary might want to conduct on the world stage.
What do you mean by covert, though? I mean, does covert just mean it's hard to figure out how the algorithm works? Because we could say that about every algorithm.
No, the covert nature of it comes from the fact that it's not apparent that the PRC is the one behind the scenes pulling the strings here and deciding exactly what content is going to be made to appear on the site. And another way that the
It's just because we don't know that China's behind it? That's what covert means?
Well,
Are they just fucking with her? Because I feel like they're just fucking with her. Do you get that feeling too? Like they're all.
They have to pretend to ask tough questions.
See, they're tough questions, but they're not letting her finish. But she's not. It's not throwing her.
So you're figuring out what the algorithm is doing. It's just because people don't know that China is pulling the strings. That's what covert means?
What it means is that Americans are on this platform thinking that they are speaking to one another, and this recommendation engine that is apparently so valuable is organically directing their speech to each other. And what is covert is that the PRC, a foreign adversary nation, is instead exploiting a vulnerability in the system.
Well, if that's
to
all it
suppress and
means, that
silence
like people don't know that China's behind it, like everybody now knows that China is behind it.
No, but it's the specific content that's being manipulated would be unapparent. And so I think
that's true of every search engine. I mean, you can take any of these algorithms, whether it's X or whether it's
good questions.
You name it. What are the new ones? Blue Sky. I mean, none of these are apparent, right? You get what you get, and you think that's puzzling, and it's all a little bit of a black box. So you can't just mean it's a black box. It's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly, really, like everybody does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening. And therefore it doesn't guard against the national security harm from the operation itself.
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China. In case anybody.
TikTok is going to put a disclaimer where you have to click through. Like you open the app and it says click through.
Controlled by the Chinese Communist Party. That'd be good.
You acknowledge that the information you're about to see is controlled by the Chinese Party.
You know, with all due respect to that solution, I don't feel like that's the narrowest tailored means. I feel like we could be maybe a little bit. Feel like we could be a little bit broader and still within the First Amendment ambit.
I've started to like Justice Gorsuch's hypos though. I like his hypos. I'm growing. He's one of my favorites now.
Oh, Gorsuch is my fave. Ever since
he's the most intellectual of them right now that I feel.
Yeah,
and intellectually honest. Like
We're left in doubt after today about that possibility. So you're saying how that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is—
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said one of—
I get her point here. This is what I was saying. You give a click through to any person and they're just going to click it. They ain't going to read it. But it's pretty paternalistic to just say, all right, ban. This is a good back and forth. This is worth the wait.
Of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here. They brought up the example of the Foreign Agents Registration Act, FARA. There you have to disclose the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content I mean, every editor, every newspaper in its editorial room makes decisions about what it's going to run and how it's going to say it. And every algorithm has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how, but they're generally aware, and we think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but I'm not arguing about the compelling interest. We're arguing about the tailoring.
Right. And so I guess what I would say, you began by saying the cure for concerning speech is counter speech. Here, I dispute the premise that Congress was specifically concerned about any particular subject or any particular viewpoint. It wanted to close off the capability of a foreign government. But in any event, it's very hard to engage in counter speech when you don't know because someone is secretly manipulating the platform behind the scenes.
Good dodge. That was fucking seamless.
She's just so good at the judo.
Are you kidding me? Oh my God. To explain why that was a good dodge, Gorsuch was trying to get her to acknowledge that this was content discrimination and that this was aimed at the content being delivered and that the law was aimed at discriminating against specific types of content. And she came out and said, no, these are not the droids you are looking for, and said, we are concerned about the mechanism of information being conveyed. And somehow did it in a fashion where I don't even think Gorsuch picked up on it. Like she just kept going.
And in particular, what the PRC has the capability to do is simply silence American voices.
Newspaper owned by a foreign company and a foreign government. You wouldn't know when it's exercising editorial discretion about this article or that article or how it's doing it. So maybe we just need to shut down the Oxford University Press in America, or you pick it, any other foreign-owned Politico, I was told today, is owned by Germany. So that would all be okay on your theory, so long as Congress designates that country a foreign adversary?
We are not asking the court to articulate bright line rules to govern all kinds of hypothetical situations.
I am testing your argument.
Yes, and what I want to acknowledge is that sometimes the court has recognized that a speaker-based preference might reflect a content-based preference. And in the context of ownership of a newspaper, for example, in part because a newspaper is a one-way channel of communication and is generally understood to represent to some extent its publisher's views, maybe the court would more readily infer that a regulation target.
We're at 1.25.
Personally, I appreciate her not willing to commit, but I'm like ready to commit to the bright line rule. She's probably smarter than me for deferring, though.
No, she's dodging, because the thing is, on this record, because we could go back to Gorsuch in that answer and say, on this record, yes. On this record with this person, yes. But she's not going to concede that. Like, she's not going to go that far. She wants to make the position seem less absolute.
Yeah, I'd make what would probably be the mistake.
I'm with you. It's just that's why I'm sitting here going, I wonder, why are you fighting these points? Just fire back. But she keeps fighting the points and she keeps fucking winning them, and I don't understand. Like, she's giving them the hypos and still winning the arguments. Here, people are angry that she sped up. I'll put her normal because she does talk pretty fast.
Targeting that is actually aiming to target content. But I don't think the court could draw the same conclusion here.
I'm not talking about the compelling interest or any of that. I'm talking about the tailoring.
Side note, this has become a Gorsuch thing, which I very much appreciate. He says, no. Stick to my hypo. Don't change it. My hypo. And I appreciate the hell out of the fact he does that.
You're saying we have no alternative but to stop this speech altogether. We can't rely on disclosure. But you say that wouldn't apply to Politico or to the Oxford University Press because?
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise distinct interests in this regard because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does prevent a distinct national security risk. Of course, the other big difference with the newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
Fuck you. That was so good. I hate you for that. That was so damn good. She took the content.
You just hate her because she's so good. We need to invite her on to Friday Night Frday. She can commentate.
She won't agree. No way she would agree. But she just went from the content discrimination argument, and she was like, but without even acknowledging it, was like, you're also mining
She's
data.
gonna be out of a job
You're
pretty
like,
soon. Maybe she'll agree to us in February, then we can have her on.
yeah, right. She's gonna be hired like Paul. You know damn well she has her. If I'm honestly, if
I'll give her
I'm this
$350 to work for
administration,
me.
if I'm this administration, I'm keeping her ass on. I don't know that there's another solicitor with this capability.
Trump already
that-
named somebody, and it wasn't me. I was very disappointed.
Well, I mean, she could argue both sides of the aisle. I don't hate it. She just literally was like, "Oh, you want to talk about content? But here, what about the data mining?" And it was so subtle that you didn't even fucking hear it because it was at the end of the answer, and it was like it completely changed the point. Oh, I hate you, but you're awesome.
General
Counsel,
Prelever, can I? Oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to
If they
foment
do, I say they're winning.
disruption or dissent.
Oh, Justice Roberts, your jokes were so much funnier when you were younger. Okay. I don't think it's TikTok doing that, bud. Maybe, Justice Roberts, this is my opinion. This is my opinion. I'm going to say this real quick. Maybe some of the argument stems from the Supreme Court not making like actual decisions and punting the football on serious issues because you want a unified court rather than making absolute decisions. Yeah, I'm looking at Justice Roberts, who routinely will fucking nuke a case that needs a disposition because it's not unanimous or it's not 7-2 or it's not 8-1. Maybe, Justice Roberts, you should stop worrying about the politics of the court and start making actual judgment calls. So, and maybe by doing that, you might lead to less divisiveness than just punting it and letting us fight that shit out. Me no likey.
That might very well be true, Mr. Chief Justice. And I think the point I'm trying to make is that China is a foreign adversary nation that looks for every opportunity it has to weaken the United States and to try to threaten our national security. And if it has...
Oh, this part needs to be cleared. No, I'm not talking about politics that way. I'm talking about the perception of the court. Not politics, meaning the public perception of the court, where you allow the public perception of the integrity of the court to sway your decision one way or the other. You are not acting as the court. You are acting as a politician, therefore engaging in politics. That is what I'm saying. I'm not saying right, left, or in between. I'm saying allowing the public perception of the court to influence your decision means that you are acting in a political fashion. And Roberts is well known for that, as I have yelled with Kurt about routinely.
He's an institutionalist.
Has control over this key communications channel. It's hard to predict ex ante exactly how it's going to use that as a tool to harm our interests. But we know it's going to try, first and foremost, by seeking to get the data of these American users, which would be of a piece of all of the activity the PRC has already undertaken to breach our laws. Hack OPM, for example, and exfiltrate the background files and security clearances of 20 million government employees. The breach of Equifax to get sensitive financial data, Anthem to get sensitive healthcare data, we know that the PRC has a voracious appetite to get its hands on as much information about Americans as possible. And that creates a potent weapon here because the PRC could command that ByteDance comply with any request it gives to obtain that data that's in the hands of the U.S. subsidiary.
Thank you.
General Prelogar.
Suppose that TikTok had no connection whatsoever with any foreign government. It was owned instead by an immensely rich multinational corporation, and Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
I think there would be a first order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of protected speech and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not.
Y'all remember when we were talking about the first attorney and how I said Alito's picking a fight and wants him to fight back? That's why I said that. Alito does this. So Alito is picking a fight and wants you to fight back, but wants you to fight back on the issue. So Prelogger challenged his initial premise and said, you need to clarify. And he clarified, and she jumped in and said, well, that depends on this. And she started down the analysis. So this is the fighting back. This is what makes remarkable litigant, class B litigant. I'm not going to say C, D, or E, but yes, that's the distinction. Alito came in the first instance and was like, here's a hypo, fight me on it. And he was like, oh, I concede the hypo. Prelogger, here's a hypo. Prelogger says, your hypo sucks. Define it. And he defines it. Then she goes, analysis. Here we go.
Regulating speech as such.
Here, we'll play it again.
And Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
I think there would be a first order question of whether the multinational corporation itself has First Amendment rights.
They're challenging the hypo. Clarify, Justice Alito.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of
concede the logical point, now make your argument and hammer it home.
Protected speech, and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control.
So your argument depends on the fact that what is at bottom here is the People's Republic of China using TikTok. That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
That articulation is so good. This was a great question. So I asked a question, does that mean that Roberts is less for the rights of the individual? I don't, it's a more, yes.
It's a bad way of phrasing it. As I said in chat,
it's not the best.
It means his primary concern is for the Supreme Court as an institution. He's concerned about the institutional respect and reputation of the Supreme Court. He's concerned that the Supreme Court is perceived well
as being. He's concerned about divides. He doesn't. Well, the more 5-4s that he brings out, the more he views the court as being less, I guess, impactful or correct, or he wants 7-2s, 8-1, 9-0. He doesn't want 5-4s or 6-3s. The problem is he lost the power to do that. And honestly, since he's lost that power, we've actually gotten more decisions that are they're difficult decisions. People don't like them, but they're at least decisions that are actual interpretations of law and not just, I don't like this case and I don't want to hear it. You at least get a fucking interpretation. You get an answer. You don't get a punt. That's I think Kurt and I very much share the same view on Roberts. I think we do, right? No.
Yeah, he is concerned primarily with the Supreme Court having a positive reputation. He's concerned primarily with the Supreme Court having respect. He's concerned primarily with the Supreme Court as an institution
and their approval. He's one of those. He's a justice that looks at the approval rating in the court. Tell me you want that. Tell me you're happy about that. I'm not.
But as Rob notes, there are 5 conservatives without him. And it only takes 4 votes to hear a case in the first place.
Which means he's heard a lot more cases that he's very uncomfortable with. And you can tell because you hear him asking questions where he's like trying to split the baby.
Yeah.
Sorry, I'm sorry.
I just wanted you to respond to Mr. Fisher's argument about the rights of Americans to receive information, say, from the PRC or anyone else, and that even if ByteDance did not itself have First Amendment rights, that Americans would have a First Amendment right to receive that information in the Lamont sense.
Yes. So I think that Lamont reflected a principle that there can be a right of American listeners to receive information. And if Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans. And also,
oh my God. All right. That sentence. All right. Here's what how many caveats do we have here? Ready? This is how she phrases it. Listen to all of the things that she says are the legitimate basis for the regulation.
So I think that Lamont reflected a principle that there can be a right of American listeners to receive information. And if
all right, so you have the right to receive information.
Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's
all right, we're regulating. We don't agree with the speech.
Obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans, and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do that.
I was trying to think of whether there's a historical analog here, and this is what I came up with, and you can tell me whether it's fallacious. In the mid-20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country. And the Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, oh, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has, do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine. It's just like this case. Or if the answer is no, Why is it not like this case?
So I guess I think I would need to know more information about how the international organization is able to exercise control over the American.
This is such a great answer. This is probably my personal favorite answer that she
This
gave
was
in
one
the
of my
entire thing.
that was a fucking good hypo too. That was a good hypo.
It was a good hypo, and it was a very good answer.
That was, here's Whitney. You want to answer it? Here's Whitney. Here's my concerns. This is what we're gonna do. So this is a good exchange. And this is why I like Justice Kagan. I disagree with her a lot, but this is a good hypo.
Controlled by a foreign adversary, which could use millions of Americans and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do
Up with, and you can tell me of whether there's a historical analog here. And this is what I came up with, and you can tell me whether it's fallacious. In the mid-20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country. And the Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said,
all right, this is fucking great. So this is basically taking a domestic entity like the Communist Party of the Americas, right? So you have, and it was informal at that time. It wasn't corporate structures that we were recognizing, but now take this hypo and take it corporate structure. So you have a corporate structure that is the Communist entity of America. And they're a corporate structure. They have a right to speech, but they're very much integrated and interrelated with this international communist structure. And we have recognized as a U.S. that communism is a threat to our democracy and our way of living and our lifestyle. This is a great hypo.
well, it's very nice. We can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has. Do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine. It's just like this case. Or if the answer is no, why is it not like this case?
So I guess I think I would need to know more information about how the international organization is able to exercise control over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more about.
Wow. Okay. So she reframes the question immediately and says, okay, so let me take your hypothetical and give you context that you didn't have in your hypothetical. Let me tell you that the hypothetical foreign entity can now come in and surreptitiously, without the domestic entity knowing, gather and extract this information. Complete control. Which, if you're looking at the context of the mid so 1920s, 30s, 40s, that didn't exist. You didn't have that power. There wasn't this way of surreptitiously going and grabbing that data and bringing it back out. There weren't servers and ability to do that. So she's reframed the question, fighting back against it.
Was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, oh, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has. Do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine. It's just like this case. Or if the answer is no, why is it not like this case?
So I guess I think I would need to know more information about how the international organization is able to exercise control over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more about sort of the content. Let's put the data collection piece of this aside, which seems not very pertinent to my 1950s analog. But, very concerned about the kind of speech that the Communist Party was making in the United States. And it turns out that that content was pretty well scripted someplace else.
I think.
And Kagan didn't fall for the trap. Kagan was like, I see you're trying to deflect. You don't want to answer the content question. You're trying to obfuscate. Come back to my hypo.
I think if it was specifically a concern about the content, then that would trigger heightened scrutiny under the First Amendment. We're not trying to run away from that principle here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're a little. I think you've just given your thing away, because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will. That concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree.
This is the whole case. Like this argument. This is. You talked about Whitney. She's rehashing Whitney.
Yep.
Agree that the concern with covert content manipulation is itself content-based, or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or.
I didn't like that. That's a bad answer. That part right there is a bad answer.
I'm also wondering, does she really have to run away from the problem that she's trying to solve? It's like, does she have to run away from this problem? Because it's like, what if she just says, yeah, that's fine? Because, this is, we go to our 1950s example. We've got the Communist Party USA. We learn that, let's take the extreme hypothetical to make ourselves happy. We learn that Russia is scripting this stuff. They themselves are writing it. And they're in complete, basically, control of what Communist Party USA is saying. The U.S. government says, no, we're not going to let you do that. You have to disaffiliate. If you want to come up with the same ideas, if you want to write whatever you want to write, that's fine. But you can't just simply regurgitate what Russia's writing. Can she not run that way and be okay?
She could, but I think she's not answering for Kagan. I think she's answering for Thomas. Or for Alito, who would be less, well, not maybe Thomas, less Alito. Maybe Gorsuch, who's going to be more offended at the content-based approach than the who's engaged in the speech.
Because it is, well, yeah, but this is the thing, like for me, like it is content-based. So you got that part of the equation, which is true. But I can still get past the entire First Amendment analysis.
I know.
By saying it's not a protected speaker, right?
But she's trying
and then I win.
She's trying to thread the needle on the content based.
Right.
She's trying to shoot that magical, I don't want to piss off one of the justices. I want to thread this needle. And I agree with you. I don't think she has to.
Yeah.
But
there is a fundamental difference between the exact, it's literally, even though it's literally the exact same word for word, it's different if it's a foreign speaker versus an American speaker.
And then the question is, are you in speech territory or association territory? Are you simply reciting the statements by the foreign speaker? Or is it your own speech? Does it matter under this analysis? No, it doesn't, because we're talking.
Well, I'm not sure necessarily the freedom of association gets you that far, because the First Amendment protects speech, press, assembly, religion, press. There's no free form right of association.
Yeah. She said something here I took issue with. I rewind it a little bit. I want to hear it again. I didn't like how far she went with it. Hang on.
has, that we can't totally see around all the corners to imagine how it could use it against our interests. But we know the PRC will do whatever it can to try. And I think
I didn't like that part. Like it phrased the concern as being somewhat speculative while acknowledging that it was content-based discrimination or content-based. Like, we know they're going to try and use it. We don't know how, but we know they're going to try and use it. Apply that logic to so many other things. Like, we don't know how they're going to use the information, but we know they're going to use the information.
But see, like, again, when it's foreign entity, I can just, that's fine. Because it gets back down to me to like fundamental concepts of like foreign relations. We're worried that in the future that this country is going to stab us in the back. We have absolutely no evidence of that whatsoever, but we're still going to, like, you know, put up our defenses because we're concerned. Okay.
Yeah, and it's the fundamental right of sovereigns. Yeah, sovereigns have the ability to defend themselves and do these things.
They're not our enemy today, but we're still putting up a fence. I mean, you know,
I get it. I get it. I think she's trying to thread a needle she doesn't have to thread. You can take the absolute position. She's trying not to. I just think that with how badly they botched that argument in the front end, you can take the absolute if you wanted it.
She might be concerned about problems that I'm not fully considering or fully giving weight to, so I don't want to necessarily completely undermine her. I'm sure she's considered this from a different angle. Also, for what it's worth, she is defending the Court of Appeals kind of on the ground that they sort of laid, because they sort of the Court of Appeals presupposed the First Amendment applied. The Court of Appeals presupposed the fact that TikTok separate actually like legally counts. The fact that there's something called TikTok USA is legally like important. They suppose that the First Amendment like exists. So she is defending on the same grounds the Court of Appeals decided it.
She's conceding the question on which cert was granted. Like, she is confining herself to the question that's being asked.
It could be that. Whereas I'm like,
that is different in kind.
Sorry, what?
Whereas I'm just like, put it out to the ground.
Yeah, I'm like, make it go away. Yeah, I get it.
From imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. You know, this law was passed by broad bipartisan majorities in both houses of Congress, and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
The court has said it depends. It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. Instead, the court has said it warrants closer consideration. And here, if you look at the US speakers, TikTok US and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
It's hard for me to think of situations, maybe they exist, where our classification.
Side note, Alito and Prelogger go at it with each other. Like, they go toe to toe a lot. They fight over facts inside the record, outside the record. They've done it all term.
Based on speaker is not viewpoint or content-based restrictions. I mean, somebody says, Joe can't talk anymore. We're going to shut Joe up. And we don't know what he's going to say tomorrow or 2 weeks from now. We don't know what he's going to discuss, but whatever he says is bad because Joe is a bad person. I mean, that's viewpoint and content-based, isn't it?
I think when it comes to a foreign adversary, it's not right to view it that way. And the reason for that, again, is this is a sophisticated adversary nation, and we can't just simplistically say, oh, what the PRC is going to want is to see more pro-China content on this app. As Chief Judge Srinivasan observed, there are various ways that the PRC could try to create some kind of false flag operation and actually promote anti-China content, not to dictate how Americans should think about things, but simply to create some trumped-up justification for a military or economic action that the foreign adversary wants to take against us. And I don't think a concern with trying to ward off that capability.
Why isn't that viewpoint or content still? We don't know what the content's going to be, but we know it, Joe, is bad.
Because I think the better classification is to recognize that what we're trying to prevent is not the specific subject matter.
These are... I thought this argument was going to be boring.
Well, you were wrong.
I was very wrong. These are really... You know what? Guy number one sucked. We didn't get to any of these really cool, fascinating arguments because he couldn't stand up to the muster of the question.
You know, for a guy who used to have Preligar's job, he's not very good at it.
Really? Tell me he did. Really?
He was Solicitor General for 3 years.
Guy number one sucked. No, he sucked.
Yeah.
We didn't get to any of these intellectual discussions. We don't get to any of these questions that actually make you think about the issue. These are questions that make you think about the issue. Kagan's question, Gorsuch's question. Like you are getting these questions that are like, huh, this is a fucking good question.
But have you considered what if we kidnap Jeff Bezos' children?
I hate you. God damn it. Why? The Supreme Court wants to have this intellectual debate. They want to understand how far your logic goes. They want to understand how it's different than Whitney versus California. They want to understand these fucking things. Just why did Jeff Bezos come up? Why? Oh, I can answer this one because Kurt is he's more of a nerd than I am. I love this stuff. Kurt loves this stuff. I talk about the theater of the courtroom. So I get to see the theater play out in court with actors that are acting in real life. Kurt can read that in words. So for all the things that I see play out in a courtroom, and I'm navigating the courtroom and the arguments being made and the objections and hearsay and all the above in an actual trial record, Kurt reads this in argument, and it's the same level of drama for him. So when he reads an impactful statement or an impactful opinion, it's like me seeing a closing argument. And it's like, holy shit, I love this person. It's the same. So Kurt remembers all of this stuff. The fact that I was reading Whitney v. California and he was, without looking at it, joining in some of the quotations.
I love this stuff.
It's so fucking cool. I love the arguments. I love,
you know, because on good days, and I don't know if this is necessarily the utmost example of this, but on good days, we're reaching for the utmost of what law is. We're reaching for the highest of it. You know, we're reaching for the Platonic ideal.
The best argument that can be made.
Pushing ourselves in every possible way.
Yeah, you want to see the best question.
That's what I live for, man.
You want to see the hardest question met with the best answer. That's what you want to see. The hardest question met with the best answer. And when that answer is not enough, you want to see the fight. I love this shit.
The specific viewpoints, but the technical capability of a foreign adversary nation to use a communications channel against this.
I guess I'm just struggling how covert content manipulation isn't content-based restriction.
So again,
it's kind of hard to avoid the word content. It's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related to content, but I don't think it reflects Congress seeking to set out in advance what kind of speech we should have reflecting
What I really
certain
want to know
views
is how
on
she
certain
stays so
topics.
calm.
Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny. And as the DC Circuit recognized here, we think that this law serves compelling national security concern.
This is where the guy fucked up in front of Justice Jackson. Jackson was like, all right, you're in strict scrutiny. You've lost it 5 out of 5. And she's like, even if we are at this point, which I don't think we are, we still win.
Oh, yeah, 100%.
That sound in some of the same arguments I'm making here, and that have a long-standing correspondence to history and tradition of trying to prevent foreign control.
And then we get to the question whether there's a less restrictive means. I get that, and whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern, Congress could ban TikTok US from sharing data with anyone, and on pains of penalties that would put people in prison and shut the company down in the future, as the government did, for example, with Arthur Anderson. Why isn't that a less restrictive means available?
So I was surprised to hear petitioner offer that up today, because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the U.S. subsidiary from sharing.
Yeah, I bet
data
you're
with
real
the
interested
corporate
in
parent.
it now, aren't you?
Hang on. No, were you surprised? Because I will tell you, as a litigator, every single time I have used the phrase, I was surprised to hear for the first time today. Every single time I have used that phrase, and I've used it quite a bit, I was not surprised at all. In no respect was I surprised. I knew damn well it was going to get raised, and I knew the argument I was going to make when it got raised. I'm sorry, Ms. Prelogger. Like, to the notion
I'm
that
sorry,
you were
are you
surprised to hear that
questioning our
today.
legal waifu?
Yeah, I'm saying she's full of shit. I was surprised to hear that today. No, you knew damn well it was going to come up today. You knew damn well, and you had an answer for it. Don't you shake your head at me. I am right.
And the reason for the branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the U.S. subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control export restrictions with respect to the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was insufficient in protecting our data privacy and security concerns.
That didn't come across enough in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor. And you don't have to take my word for it. You can look at the specific.
Hang on, I got to take issue with this one. Strong disagree. Emily, I used this today. I used this today in a court hearing. And I said, I'm surprised that they would first raise this issue now when asking for a continuance. I was not surprised. There should have been a narrator like over my shoulder. In fact, he was not surprised. I get it. However, it's the
now,
unsurprising.
Wait a second. Am I to understand that you displayed less than full candor to the tribunal?
We're going to call it hyperbole. We're going to call it argument. So, I'm surprised is a statement of opinion, I think. We're going to go with that. Because I don't like your question and what it insinuates. Because it caught me off guard. I don't like it. Kurt, I'm surprised that for the first time today, you would make this argument. You son of a bitch. No. But yes, the I'm surprised is a yes. I was totally planning for you to do this, and here's my recited, entirely unrehearsed phrase and response that will completely destroy the argument you just made, that I was waiting and thinking that you might make, kind of hoping you would make. And thank you for doing so, because I get to smack you down. That was my feeling this morning. This morning was a good morning. It was a good morning. I enjoyed this morning. However, it's 1:40, so it's probably yesterday morning. Yeah.
Maybe next time you could just say, I'm delighted for this brain dead layup of a question that the opposing counsel gave. That'd be good.
No, I don't think you can say that in the Supreme Court, Kurt. I think they look down on that. Like, Justice, I'm thank you for the brain dead question that allows me to smack the other side down. Got to be more artful. It'd be like attorney, like General Prelogger. Yeah. I'm just laughing. What? I'm surprised you would be stupid. There we go. There you go. I'm surprised you'd be stupid enough to open the door to let me go. That's still surprise. That's true, I guess. I don't know. I know, Terry. It took me a second to figure it out. It takes me a minute to learn these things. It is 1:40 in the morning. Give me some grace, please. Plus, I'm dissecting Supreme Court oral argument over complex First Amendment issues. Like, I can only do so much at one time. That's why I have Kurt here helping me, because my brain cannot process and do all the braining it needs to.
Terms of the National Security Agreement that ByteDance itself proposed. The relevant definition of the accepted data is at JA 239 to 240, and it references categories of information that would, of necessity, technological necessity and business necessity, have to flow back to China. And the relevant categories are in the sealed appendix, but I would really encourage the court to look this up because it's eye-opening. It is at the Court of Appeals sealed appendix 249 to 252 and 254. If you look at that information, it was a wealth of data about Americans that was going to have to go back to China in order for the platform to just continue its basic operations. And there's a legitimate commercial justification for that, but it creates this gaping vulnerability in the system because once that data is in China, the PRC can.
This is now my first experience with a sealed appendix.
No, but it's so great what's about to happen. Justice Gorsuch is about to make a mistake, and she's gonna smack him with it.
Oh no.
Yeah.
Who's about to make the mistake?
Gorsuch is about to make a mistake.
No. Oh.
Yeah. And she's about to smack him over the head with it. It's great.
He's going to refer to something in sealed appendix. Oh no.
No, he misunderstands what she means. You're about to hear him, he's about to say, "Oh, I don't know that's fair for you to refer to the sealed appendix because we get to see it and you get to see it, but the opposing side didn't get to see it." And she says, "No. When this is the sealed appendix by their request because it was their trade secrets. It was sealed at their request, it's their data, so they're fully aware of it." It's not secret. It was part of the
They
seal because of
requested
trade
the
secret.
sealing of it, and they're sitting here saying First Amendment, free speech, all public platform, and they're like,
so
"Oh
he's
my
like,
god,
he shouldn't
public."
refer to the classified material. It's like, I'm not. I'm referring to their trade data. So great. Whoops.
Mini Mischief 1 is only a wee youngling. But I'm going to start playing like her clips of pre-logger and just be like, can you please just, if you can emulate this, you can hate me all you want.
What I think you need to do is you need to get every word pre-logger's ever spoken together, put it into a large language model, then get 11 labs to clone her voice, and then you can ask pre-logger any questions and hear back the answer in her voice.
And then she can emulate, yes. Because Mini Mischief 1's going to be a lawyer. She's too...
And then if you have a spare $170,000,
I will figure that part out, Kurt. She's too smart. She's too argumentative. She's got that wit where you make the comment and within half a second it's there. You're like, how the shit did you come up with that? It's already there. So I just have to find a way to channel this intelligence into her, because if she learns from me, she's screwed. But I need Elizabeth Pre-logger to teach her. Kids are ruthless, by the way. They're so brutal. Like when they come up and they give you a hug, Kurt, there's a lot of things that like hurt the feelings, but when a kid comes up and gives you a hug and they do the belly pat, they're like, do. It's like, that's bigger. And like, oh, that hurts so much more than you think it does.
Demand that ByteDance turn it over and keep that assistant secret. And the one final point on this is that ByteDance was not a trusted partner here. It wasn't a company that the United States could simply expect to comply with any requirements in good faith. And there was actual factual evidence to show that even during a period of time when the company was representing that it had walled off the US data and it was protected, there was a well-publicized incident where ByteDance in China surveilled US journalists using their location data. This is the protected US data in order to try to figure out who was leaking information from the company to those journalists.
General, you want us to look at that, and you get to look at it, but your friends on the other side don't get to look at it. That doesn't seem fair.
That's Roberts.
Oh, sorry, Roberts.
That's Roberts.
My fault.
Don't you defame the white-haired gentleman. That's Roberts. Wait.
Okay, the Chief Justice made a mistake.
He just stepped in it, like full on.
The sealed appendix. This is the protected US data in order to try to figure out who was leaking information from the company to those journalists.
General, you want us to look at that, and you get to look at it, but your friends on the other side don't get to look at it. That doesn't seem fair.
That's the sealed appendix, Mr. Chief Justice. So it's their information. They can look at it. It's just under seal to protect their proprietary business information.
Whoops.
General, so I want to go back to the discussion about content discrimination, and we're going to shut Joe up. Here, it seems to me like we are saying.
I don't know. The shut Joe up felt so.
Which Joe are we shutting up? Which
we're gonna shut John Roberts up. We're gonna shut him up after he stepped in it. We're gonna shut him up after he stepped in it, and we're gonna go to a different hypothetical because that was horrible.
To ByteDance, we want to shut you up. And so let's say that I think that that is content discrimination based on speaker. Tell me if I think that, tell me if I have to conclude that it is also speaker-based discrimination and content-based discrimination for TikTok.
No, it is not. And the reason for that is because it would be an anomalous principle to say that an entity outside the United States that can't assert its own First Amendment rights can somehow manufacture that right through the expediency of forming a U.S. subsidiary, especially one that it wholly controls.
So you don't have to.
Oh, fuck you. That was such an articulate way of saying it. God damn it.
I keep getting confused because you keep saying fuck you as a sign of respect. It's very confusing.
I'm sorry. I'm sorry. Can you recognize the frustration in how articulate that was to phrase that way?
Mm-hmm.
And that why I'm mad that was. For those of you who missed it, we're going to rewind very, very shortly. Like this, come on. We've been talking about proxy and puppet. We've been using all these different phrases that have been used a million times before, right? You're using them as a sock puppet, a marionette. We've talked about all these different things.
And content-based discrimination for TikTok.
No, it is not. And the reason for that is because it would be an anomalous principle to say that an entity outside the United States that can't assert its own First Amendment rights can somehow manufacture that right through the expediency of forming a U.S. subsidiary, especially one that it wholly controls.
So you don't have to stand.
I'm so mad that that is so wonderfully phrased. That a company outside the United States could manufacture that by creating a wholly owned subsidiary, expediently regard like just it's a long, very beautiful way of saying sock puppet.
And on that argument that you were having with Justice Alito and Justice Gorsuch to still have your point about content discrimination.
That's right. And I think if you're focusing in on the relevant U.S. entities here, TikTok U.S. and the users themselves, this act isn't regulating them in any way. It's not trying to dictate the algorithm that TikTok U.S. can use. And in fact, Congress, I think, was doing everything it could to preserve access to TikTok in the United States in recognition that Americans enjoy expressing themselves and building community on the site.
Well,
One last quick question. Sorry, just one last quick question. Justice Gorsuch had asked your friends on the other side whether the new administration on January 20th could extend the deadline. What's your position on that?
So I think it tees up a statutory interpretation question of whether there can be an extension after the time period for divestiture has lapsed. I would think the court might start with its decision in the Hawley Frontier case, which did recognize the ability to get an extension after a lapse like that.
So it's your position that they could?
We have not run it to ground, in part because it's simply not presented here, and I'm not prepared to take a position on that statutory interpretation question. I do want to emphasize that.
I'm surprised then she gave as much as she did.
That
I'm
was
surprised.
I'm
I'm surprised that she said, "Well, it looks like they can under this relevant case law," and then refused to expand further. It's a very odd.
She did the run up all the way, but then she also had the balls to shoot back at Coney Barrett, which she didn't want to answer anymore. And she's like, "I'm not going to do that." She should have done it earlier.
I'm just surprised that she's like, we didn't brief that, so I don't know.
Yeah, so why stick your toes in?
Especially relating to a new administration, because the answer seems like it helps the new administration, which seems like a slightly odd choice.
But the answer is I don't know. Like that's the answer. I don't know. But it was well handled. Then Barrett pushed again, and she was like, "No, I'm not answering." First of all, if I'm in front of the 9 justices of the Supreme Court and they're like, "Here's a question," I don't know that I would have the balls to like look back and say, "I'm not prepared to answer that question."
If you didn't prepare for it, then I don't think there's anything wrong with that. It wasn't in the cert. It wasn't in the cert. It is a hypothetical about something that hasn't happened yet. I mean, I don't think there's anything wrong with that.
That's fair. It's just they have caught so many lawyers off guard with that. They catch them all the time. Get them outside the briefs. That was a weird turn of phrase. Get them outside the briefs. Got it. All right. A couple more minutes. Let's go towards her closing salvo.
The Chinese government to have this vast.
in other cases, or do you think that the January 20 deadline prohibits us from doing that?
I don't think this court has a formal basis to not issue an administrative stay if it believed that that was necessary to assist in the court's own consideration of the case. And I would obviously defer to the court and whether it has a sufficient time to resolve the case. But we are here ready to submit the case today. And I think it is in the interest of Congress's work and our national security to resolve the case and allow the statute to take effect.
Can I just test to see whether your recollection of what Mr. Francisco said about a warning is consistent with mine? I did not hear him say, he can address this in rebuttal, that it would be acceptable to his client if Congress had said there has to be a stark warning on every TikTok, such as, warning, the communist China is using TikTok to manipulate your thinking and to gather potential blackmail material. Did you hear him say that that would be okay?
I don't think he's made that concession, but even if he had, I don't think that would address the government's national security concerns. And one of the points here is that it's not just data privacy. So
all right, that was a backhanded slap because Mr. Francisco came all the way and basically said that.
Yep.
He literally said we can do a disclosure. He said that out loud in response to a question.
I like if disclosure has to pop up on every single video. That'd be good. Every single video warning may be under the control of the Chinese party. That'd be good.
Yeah. I hereby acknowledge the content I am watching is under control of the Chinese Communist Party. Oh my God.
But law and lumber is not under the control of the Communist Chinese Party.
No. No. Not yet. Not ever. Come on, man. I don't have enough time to be under control of anyone. I'm under control of this dog and these two fucking kids. They control a lot.
even if you could somehow put users on notice that the PRC could obtain their data and they choose to disregard that, it's not a data privacy interest, it's a national security interest. There's a distinct sovereign harm to the United States if our foreign adversary can collect this massive data set about 170 million Americans. And as Justice Kavanaugh touched on, there are a lot of teenagers using TikTok today who might ignore a warning like that and not really care, but they're going to grow up and they might become members of our military. They might become senior government officials. And for the Chinese government to have this vast trove of incredibly sensitive data about them, I think obviously exposes our nation as a whole to a risk of espionage and blackmail.
Thank you.
Pretty good point.
I did want to touch briefly on the questions about.
For everyone saying this is conspiracy theory stuff, it's not. The number of hacks that have been released of the US, the IRS data, Cloudflare got hacked. Who else? We've got
OPM got hacked.
And every one of them tied back to the Chinese government, the actual Chinese government. All of these hacks. So this speculation about the actual use of this algorithm or this app to get additional information is not speculation. It's not paranoia. It is actually proactive defense, because the US government and all their entities are getting hacked every 2 seconds. Every 2 seconds. DOD hack, yeah, the big DOD hack that came out, was it a month ago? There's hacking everywhere. And 90% of them are being attributed directly to the Chinese Communist Party, the Chinese government. This is wild. Like, yeah. Oh, I'm sorry. I wasn't drawing attention to you. It's just people in the chat. I'm sorry, saying felt my thoughts before this felt crazy. Yeah, no, it's not. This is not random conspiracy. This is real. I think the media's downplayed this a lot. The media has been in the hands of a lot of the content creators. I get it. There's a big platform that's going away. And that's we don't have to go through more of this. Like here's the thing. I don't know that this is going to be 9-0, but it feels like it.
Yep, it really does.
I understand that there were a lot of questions being asked of General Prelogger that were kind of like, you kind of have to understand how to read the court. The questions being asked of Prelogger was, how far do you want the rule to go? The questions being asked of Francisco and the other one was, your rule is stupid. And you have to understand the difference between the two. Guys, Kurt has been up since this morning covering this live. I was in court. Kurt was covering this live. So, I think this is going to be 9-0. I think maybe, I don't know. They going to flip a Alito? No.
No, I think it's more likely not to be 9-0. They were beating up on it pretty hard. And I think that this is defensible. The thing that's sort of like at the back, for me, is a lot of ways to go about defending this. But you have an act of Congress. And so like probably the easiest way is just simply to say, this is a political judgment. This deals with international relations, which is within the control of the policymakers, namely the executive have passed a law. Congress has passed a law that says this, and we're not going to second guess their judgment on this issue.
But are they going to get to a First Amendment analysis? I don't know that they will. Like, are they going to start applying scrutiny? And what level?
I don't really think the First Amendment applies here.
And that was my thought. I don't think
the First Amendment applies here.
And that's what I think my big debate was in a lot of the discussion. It was when they keep saying, like, let's assume the First Amendment applies. I wasn't ready to jump to that assumption. And I don't think they were either.
Yeah. The thing is that the algorithm, as they were more than happy to confirm, is under the control of China. That's the thing at the bottom day. So you have kind of three problems. You have the collection of user data, which itself is like a massive problem because you're talking about who they relate to, what kind of content they watch, when they watch it, where, on what devices, at what location and times, on what Wi-Fi, and with whom, and blah, blah. I mean, just the endless data that's available for collection, plus user keyboard data, plus user camera data, plus user microphone data, plus. Okay, the list is endless. So that's user data is problem number one. Problem number two is we are going to show you the content we want you to see. Problem number three is we're going to prevent you from seeing the content we don't want you to see.
Yeah.
And all those feed into the massive issue of serving Chinese interests, whether that is gaining information, showing you propaganda, undermining U.S. security, interfering with elections.
I mean,
whatever our bag is. So whether it's just to show you silly cat videos so that you'll be entertained by the shiny object, look at the shiny keys, so that you're not paying attention to what we're doing in the Chinese Strait, whatever. I don't know.
That's Kurt. That's a part that you're minimizing. But I was trying to make this point earlier, where content manipulation and speech doesn't necessarily mean like I am shoving information down your throat. No, it actually just means speech and consuming your brain power. And whether it's diverting your intellect or trying to persuade you in one way, or it's subtle persuasion. Like, let's say you show a bunch of cat videos. I'll give you a perfect example with regard to the kiddos. YouTube has a lovely child filter on it that says child content approved. I came downstairs one day and the children were watching this cake assembly video, right? It's just someone just assembling cakes and the volume was muted. And I turned the volume on. There's a little bit of a tone, but then all of a sudden there's like a reader, someone who's reading an article or something in the background. And I was going, this is a fucking cake video. What the hell is this? And Mini Mischief 1 goes, oh no, this this has started happening on this channel about like a few weeks ago. I was like, wait, what? Yeah, it used to be just cake videos. And then this person started talking to us, but we didn't want to watch it. I just wanted to watch the cake video. So I muted it. And I was like, one, good. Very, very, very good. But holy shit.
Yeah.
For people to think that this doesn't happen in a very subtle fashion.
Yeah.
Is remarkable. It happens, whether you think about it or not, whether it's with kids that you're talking to or the other individuals you're around, it happens. So the idea that this is just something that's just speculation or, oh my gosh, this could never be the case.
Yeah.
Come on.
So
It's
for
more than
me, it's like, as I was saying, like these are the three problems. All three of these problems are fundamentally controlled by the algorithm.
Yes. Which is
right.
owned.
And the algorithm is Chinese. That's the problem. So Project Texas doesn't solve that problem because the data might stay in the United States, but the algorithm is Chinese. And the algorithm is the speech. Like that's what they say. Like the algorithm is the speech. It's like, fine. It's like, okay, great. It's speech by ByteDance. ByteDance is not protected by the First Amendment. So like for me, this is like really simple. It's like, how simple do you want me to make this analysis? It's like, I think I said this earlier in the stream. For me, it's like, I just go simply to, it's an import control. It's customs. It's a good that wants to flow across the border. We don't allow you to bring in Cuban cigars. We don't allow you to bring in drugs. We don't allow you to bring in the TikTok algorithm. Why? Because we're God. Because we control our border and we say so. It's like that's the end of that analysis, right?
And you know
like,
what's funny about that?
Well,
You know what's
pretty
funny? You know what's
simple.
funny is there's this argument that takes place across the states, state by state, based on where your IP is right now. You can access certain content or you can't, and I mean certain content as in certain content that's inappropriate for a certain audience.
Well, that, to be fair, a lot of that is being done by the companies themselves.
Yes,
because they're the ones preventing it. So the kind of content you're interested in, like the laws don't prohibit that content from being shared. They require them to collect user data that the companies don't want to do for whatever reasons they want to do.
Correct.
So it's not quite the same thing.
For example, but it's a condition.
Yes, and also the
Similar.
regulation that prurient speech has a whole other content behind it, but we don't have time for that.
But but in this regard, when you talk about the ByteDance thing, the question being asked of ByteDance and TikTok is great. You want to operate? Congratulations. You want to operate? Very simple. Divest.
Yeah, divest. And they're like,
oh, it's so hard.
Well,
we can't do it. It's not possible. And then you and I were talking about there's probably a switch.
It'll become real possible real fast. I'm quite sure. Yeah.
So
for me, I don't think the First Amendment applies. So it's like I simply say, look, they concede that this is that the algorithm is Chinese. They concede that it's controlled by China. It's their technology. It's under their control. That's what they're using at the moment. They could use something else, but it's not. The algorithm is Chinese. The United States government has, through its infinite wisdom, decided that we don't like that, and they're allowed to make that decision as a matter of policy. And so there's no room for us to second guess that decision. And then so the First Amendment argument doesn't go anywhere. And then we can do like the other arguments that don't really go anywhere. Like bill of attainder doesn't work because it's not criminal. Fifth Amendment doesn't work because it's not a taking. We're allowing you to sell it and it doesn't destroy all economic value. So it's not a taking.
Wait, pause. Apply the taking, because there was a question about this. And I started. Apply the taking analysis because I wanted to bring this up and we can talk about it now. Because you made the Fifth Amendment argument.
Right. So the law on these issues is when you have regulation that's inhibiting something about whether or not it's a taking. The answer is it's only a taking essentially if it destroys all economic value in the thing.
Yes.
So, for example, to keep it trivial, there are a lot of rules that say, for example, that the power company has the right to, dig lines and put them in your yard. Okay, and the government's going to allow them to do this. This is not a taking because it's an intrusion, but it doesn't destroy the economic value of your land. It doesn't prevent you from doing your land.
you get a limited, so there's eminent domain, you get limited compensation for that, for an easement like that, where the government is coming and inhibiting the total value of your property. But when you're talking about an ultimate taking where the government is required to pay you the full economic value of what it is they took from you, you have to destroy all economic value to the property.
Right. So
and
so here
honestly,
all
the
economic value
government,
is not destroyed because they're allowed to sell it.
they have other platforms on which to use it.
Yeah. So the Fifth Amendment argument doesn't work. Bill of Attainder doesn't work. First Amendment argument doesn't work. Equal protection argument doesn't work for the same reason the First Amendment argument doesn't work. You're just simply not protected by the Equal Protection Clause. Lol. So like you're not protected by that either. So that argument doesn't work. Yeah.
You don't have the same protection. And that's was my question, was why was this a 3-hour argument? Because the question always came to me of, and the funny thing was about this was the TikTok lawyer, he roasted his own case in the first 5 minutes.
Yeah.
I'm sitting here going, wait, you had an avenue to pursue and you immediately went with, so what if we're a sock puppet? And
Yeah, so what if we're a sock puppet? And worse than that, what if we're a sock puppet that's using draconian, oppressive, coercive force?
Yeah.
So what? I'm like, what do you mean, so what?
That
what kind of a question is this?
You came into the Supreme Court, you said, so what if we're a sock puppet and we kidnap the kids and here's our remedy. They get to disclose.
How about we're going to war? How's that for a remedy?
No.
Damn, what the hell are you talking about?
We kidnap the kids, but here's the remedy. They get to disclose.
Oh yeah, they get a disclaimer
that we have the kids hostage, and that
like a black box warning on a cigarette pack,
and that cures it. So before you read the Washington Post, as long as you click a notification, this is the fucking logic, by the way. This is the logic. Before you read the Washington Post, as long as you click a notification that says, I hereby acknowledge that Jeff Bezos' children are being held by the Chinese Communist Party, and that in so holding, it might persuade the information I'm about to read. And you're like, okay.
I have to tell you that would somewhat upset me as an American.
Just a bit. You think Congress might have an interest in regulating that?
As I say, it's like, I think Congress has an interest in going to war. It's like, holy shit, it's like, what are we talking about?
5 minutes. 5 minutes into that argument. And I was going, why are we here? But the argument got really interesting because there's a whole lot of debate that people are very curious about in this space. I mean, you kind of wish there was better arguments being made by TikTok and the creators.
Yeah.
Especially when you're going against Prelogger, who's going to just decimate.
Yeah.
It's not
so
fair.
I hope they keep it simple. If I'm a betting man, they'll probably just adopt the reasoning of the Court of Appeals and call it a day.
I don't know. I don't think they're going to I don't think they're going to say for supplies. I think they're going to be, if they're divided, it's going to be divided on whether the First Amendment applies or not. And I think it might be on the First Amendment application, I'd give you 6-3. But I think on the ultimate issue, 9-0. It's not even close.
Well, yeah, assuming the First Amendment applies, then I'm still more than happy with strict scrutiny. So I'm happy. I'm happy with that too. If you want me to say strict scrutiny, I'm happy with that too. I mean, he proved it was strict scrutiny 5 different ways. So which one of them do you want back? Yeah.
I'm going to hit some super chats and then get out of here. Kurt, you want to stick around?
Sure.
You got it. Zom, thank you for being here. Thank you for the super sticker. Outside the box and social media brought me to you, Ian, Emily. I'm almost 4 a.m. in Ireland. I wake up randomly in the middle of the night and you guys keep me company. Live replay crew. I laugh and learn. I can also recommend Kurt Uncivil Law for content, especially related to Supreme Court. That is his freaking forte, man. If you want to understand a Supreme Court case, yeah, Steve A. Kermit doesn't have speech. Henson does. Exactly. Thank you, Steve A., for making my point. Angela, does this potentially open TikTok to losing safe harbor for saying their algorithm is speech?
People are already suing along those lines, so no.
I don't think so. Yeah.
You're thinking about CDA 230 is the question. You're thinking about
no,
whether or not it
no.
removes safe harbor from CDA 230.
No, it doesn't. No.
Well, kind of yes and kind of no. It doesn't in so much as it relates to the moderation of content, but it does potentially in so much as it's promoting content.
But for the purpose that people are actually trying to sue the content, the algorithm for, like the majority of the purpose is about the moderation of content, right? Instead of promoting content. I think they're very different analysis. Sorry. It's late. It's 2:14 a.m. my time. Scott Kirby. So you see the part, the other woman and the wife versus Kay Jacobs sued about cheating coach using the wife's toys in the bedroom and haranguing therapist. No.
Is this the one with the website that promotes cheating that's getting sued?
I didn't know this. What is this?
There's a website that promotes cheating that's getting sued. I think that's the one they're referring to.
Okay. Sister Marionette is the best nonsense. Okay. Red Rogue, thanks for your member. Matilda, good morning from the Netherlands. Good morning to you. Wiki Mon, Steve, good evening, morning, day, everyone. I hope 2025 has started well for you all. Myself as well. It's off to a great start here. And hope for you as well. John Scott, she's artful in how she fights the hypotheticals, makes it seem like she's not actually fighting it. Yeah.
She's good.
And I hate her for that because that's very, very talented. XCDA, thanks for this. I love hearing the commentary on the Supreme Court arguments. I love pre-logger. Me too. I hate some of the arguments, but I love the way she argues it. Snoopykins, just saying hi and hope you have a great weekend. You too, Snoopykins. Happy to see you here. Lady Fang, I worked in a hospital that's had its entire computer system hacked by the Chinese government. We also weren't the only hospital it happened to. That was one of the things I was talking about. This is not a fabricated threat. This is a real thing. SOAP API, I'm sure it's been covered, but the CCP has a requirement where businesses with 10% employees must have a CCP member within their business. Oh, it's more than that. They actually have an express provision that the government can direct you to do certain things. That was acknowledged in the first 5 minutes of the argument by TikTok US. So AP, Rob, would you say TikTok is astroturfing? It's late. I'm going to pretend I don't even know what that phrase is, to be honest.
AstroTurfing is fake grassroots.
Oh. No, I think they actually have a lot of creators that are very upset. I just think the creators are upset at the wrong person. Potentially criminal, ratchet people, necessary for a functioning society, the right of the people to twerk and bear Timu goods shall not be infringed. Oh, Sean. Always, never change, Sean. Never change. Irina, hi, Rob and Kurt. Replay crew sends regards. Thank you, Replay crew, for being here. It's 5 hours and 31 minutes in. XCD8, thank you for memberships. Azam, you're still here. Aren't you tired, Rob? It's past 2 a.m. Yes, I am. And I'm closing out. Aya, thank you tons for going down this rabbit hole. Really good stream tonight. Also, now I think she is my legal crush. Also, great stream. I would also recommend any argument by Paul Clement. You can have 2 crushes. Guaranteed.
Olson's also pretty good if you want to listen to Olson.
Is?
Olson?
Yes.
Olson?
What did he argue recently? Was he the one that argued the EPA case, the California EPA case?
It could be.
There's some good actors there. Chris Clements started watching LawTubers during Rittenhouse and came across you in depth. Glad you're still doing well. What is this cheating website asking for a friend? Well, here's the thing. If you ask for that friend too much, you might end up hiring me for a different reason. So we're going to leave that one where it is. We're going to wrap tonight. Thank you for being here. Kurt, thank you for chiming in. Thanks for sticking around so long, man. I love talking Supreme Court stuff with you, buddy. I really do.
It's been a hot minute. Thanks for having me.
It's been wonderful. I'm glad having you, bud. For those of you who are here, please go check out Kurt Uncivil Law, especially the Supreme Court content. Thank you for being here, guys. It's late. I'm going to wrap. Much appreciated. Thanks for sticking around, and get out there, go make something feel better. I guarantee it's going to happen. And that's it for this evening. I'll see you guys next week. Again, thank you. Night, guys.